Item 5, my lord. I'm not able to take instruction. Let it come after 1 month. In the meanwhile, I will try to take instruction.
What instruction? These are 99 matters, sir.
My lord, my lord.
Whole matter. What instruction you want?
Whether he is
Asking for life status of the person. He is alive or not?
What
What
was
is-
his age? Let us see.
Age is 49. I
15.
50.
He was 22 years in the year
At that time.
99.
At that time, yes, sir.
He is in the 50s only. Presume that he is alive and argue.
But I have to.
I'll like accommodate you, but I'll let it be there in the list. You prepare and do.
Can-
There's 99 matter. I don't want to, Let it be there. I'll accommodate you today. Don't worry.
Yes, my lord.
Let it be there in the list.
My lord.
Get ready and we'll see.
Not today, my lord, sir. That just.
Not today, obviously.
My
Not today. Don't worry. Yes. Any message? Any?
Your Lordship,
Yes.
item 23, on behalf of Mr. Ajay Kumar Nanda, I may be allowed to take the copies of deposition in a pen drive, Your Lordship.
Item 20.
23.
2007 matter. Yes, you can take it.
I will let Your Lordship.
What did I tell you?
Item 1. Item 1, you also have already given the instruction obtained from the superintendent of excise, your lordship.
How many appellants are there?
Appellant, sir, here is the appellant is the owner of the truck, your lordship. While the London trial court has convicted the two other accused persons, they are not the appellant here. Appellant is the owner of the truck, who was involved in the transporting the contraband article. Therefore, the London trial court is directed for confiscation of the said truck, your lordship. Your lordship last time directed whether the, as per the order passed by the London session judge, the superintendent of excise has confused the truck or not. I have given the paragraph 5 of the second page of this brief. Your lordship. Instruction.
Also, the sentence can to undergo imprisonment for 3 years.
Paragraph date at
Confiscated the truck. Yes. What is the instruction?
Paragraph 5, your lordship, relevant page, your lordship.
Paragraph 5.
It is also brought to the kind of the Honorable High Court of Orissa that the Honorable District Judge Jaipur.
Hey, where are you reading?
At the second page of the brief,
Second
the
page.
first page, the.
I read it brought to the.
Yes, yes,
kind of confiscated the seized truck bearing number from of in connection with to the state as record. There is no record available.
That is there, your lordship. But Superintendent of Police is, yesterday I have told you the phone, the phone. He has requested me, your lordship, grant another 10 to 15 days. It is able to ascertain the documents, your lordship. On the grounds, at that point of time, there is one district, your lordship. Now there is a bifurcation.
No.
of two
What was the order? Confiscation or it
Yes,
was given in Jimma?
Yes, your lordship, the directed to produce the vehicle.
No. Just see whether it was given in Jimma or not.
Yes, that is there also kindly the judgment last portion, your lordship.
Where is that statement?
That is the internal page of the 23 of the judgment, your lordship.
1 minute.
The seized truck of the Ethison, so it is in Jimma of the M. Appala Narsama.
Accordingly, where page 20?
Internal page of the judgment 23, your lordship.
Yes.
Last 3 lines above. The seized truck so and so, which is in Jimma of M. Appala Narsama, the sale proceeds of plant are conveyed to the state. The order of disposal will be carried out after the
Apla Narasimha and the sale proceeds of so and so you confiscated to the state. Yes. But it was in the Jimma of the
owner of the
applicant. Who
Yes.
is the applicant here?
Here's the M. Appala
It
Narsama.
was in Jimma. It was taken and confiscated. Yes. What do you say? You are in item 1.
Yes, Your Lordship. On behalf of Mr. Ajay Kumar Nanda, I am appearing.
You tell me what exactly the factual position.
Your Lordship, the accused person, they were the truck driver and helper of that.
That I know. What we are asking is, it was given in Jimma to you.
Yes,
It
sir.
was confiscated. Was it recovered from you and put to sale? And sale proceeds were deposited in the court. What
Yes.
happened?
Lordship, for that I have to take
The
instruction.
problem is neither you are able to say, nah, he.
No. There is a whole way, Lordship, my difficulty is that there isn't one district. Now 2 districts are there. Lordship, the superintendent of excise has yesterday only requested if another 10 to 15 days, it is also ascertained whether the Jima has recovered from the appellant owner of the truck or not. That to be on and to find out the documents pertaining to the case record, Your Lordship.
And you have not also not got the any information whether these two accused who were convicted, whether they have filed appeal. What happened to that appeal?
Here, as
If
to-
in that appeal they would have acquitted, the situation will be different.
and then I'm deal obliged, Your Lordship, ascertain.
Then what?
But-
it's
But what
nothing-
happened, here is a case arising out in 2BCC case. It is not able to ascertain from the Honorable Court's website whether the present two accused.
Website, he has to go and ask it.
Yeah, Lordship, that part.
You can't have the luxury of sitting in the office and do it.
No, that is not there.
He has to go and get it. Pursuant to the order dated 14/10/2025, the Superintendent of Excise, Raigada, has placed on record a report dated 28/10/2025, 25, inter alia stating that the information sought by this court, no document is available on record regarding the information sought by this court by the order dated 14/10/2025. Mr. Mohanty, legal counsel for the state, submits that one more week may be granted so that the superintendent of excise will physically verify from the court record regarding the status of the case. Please the matter next week.
Which chapter,
Matter on 11th.
Lordship, another 1 week after, Lordship, because Lordship,
11th only you tell him, write a letter.
Yes, sir.
Under that pressure, he will continue. Because he has applied mind to some extent. Now he can go and get it. Okay.
Yes, yes.
Yes.
Item two.
Reports are not come with them.
Yes. Yes, madam.
My lordship, adjourn this matter on coming Thursday.
Report. Yes.
Report has not come.
How many days you will take? Okay.
Although appellant
order
is
dated
49 years old.
2025 has not yet been complied. Let the counsel for the state seeks a last and final opportunity. Lease the matter on 11th. Yes. Item 3.
Item 3, sole appellant died, my lord. I have given the
The
report
sole
along with,
appeal died in the
death certificate.
Remitted. Yes. Item 4.
Yes, sir. Not there.
Yes, madam. Record?
What's this do?
No, what do you want?
The last occasion, the whereabouts of the person was.
Acha, whereabout. Okay. Have you got?
Not my lord. Not ready because this is only conviction 3 months and 1,000 rupees. EC Act.
Yeah, argue and finish it up here. We will
Yes,
not
yeah.
wait unnecessary. Because these people are not going to get it.
The
Pass
last-
out.
No,
You are ready? So argue and finish it up.
prosecution case is not heard by your lordship.
I don't remember so many prosecution cases. Let us start. We'll read it. Yes.
And dated 10/4/1999.
You have prepared anything?
Already submitted in last.
Okay, file it.
written note.
Okay, we'll see. What is the offense?
Offense is section 7 of.
EC Act.
No, it's ECA. Oh, Acha, you have the, yes. Yes. The truck driven by Prashant Kumar Adhuri. Four witness examined, huh? One is the two independent witnesses might not have supported the case. The same story everywhere. And one PW3 and PW4.
Oh.
These are the two.
3-4 independent.
Let us see what PW3 says. I have heard it for sometimes. I've heard it.
The only thing is that whether there is discrepancy in the FIR
Hmm.
regarding the bags, which was seized by the police.
35
Yes, but it is 35 in FIR. In charge sheet it is 32.
32.
Yes, and when it was in the Zima, you also that is 33.39 quintal. Per quintal is per bag is 1 quintal. That must be 35 quintal.
Hmm.
In the charge sheet it is 32. And
Let us see.
letter it
Let us see in the FIR you say in the FIR
Yes.
in the you say in the FIR 30 FIR 32 bags 35 bags, huh? Charge sheet 32 bags, and the weight says 33 points. Who says it? PW4.
is here.
Who says that? PW4 or who has said that? Because PW4 has said that. PW4. Bags rice.
Yes.
35 bags rice.
Different. Scissor list your worship. The Zima.
He says PW4 say 35 quintals. And who says 36?
That is
No, somewhere I've seen 33 point some. Where is that?
Zimanama. Scissor list Zimanama. It's 35 basta chawla, 33 quintal, 9 kg basta. Sorry. That is written there.
PW3 also says 35. Where from you got 33?
The scissor list you.
Exhibit. Scissor list exhibit, huh? Where does it say?
Yes.
In scissor list is 35 bags, rice, weighting 35 quintals.
33 quintals, 39 kg.
Where from you got that?
PW4 can you see also?
PW4 says, huh?
To PW4 second question. 53.
One
Scale
minute.
54. The
One minute.
total weight of the seized rice. Question to court yours.
Where is that? Both cement and rice bags seized. Which para?
3 para পরোটা 2 কোট লেখা আছে
Para 3.
para 3 তরোটা 2 কোট যেটা লেখা আছে the total weight of the seized rice.
2 quart. Yes, 2
not
quart.
35
33.39.
but not 35 as stated earlier.
.33.39 kg. So there is difference.
Yes.
Wait.
It's in.
Let us see the charge
actually,
sheet. Your charge sheet, she says charge sheet 32. Let us see charge sheet says 32. Where is madam? Huh? In the charge sheet? Transported 32
Bags.
32 bags of rice.
Yes.
In the charge sheet. What is correct? Then let us give benefit out of it. Huh?
Here it is 32, but the weight is 33 point
No, no. In oral evidence it is coming. Seizure list it is coming 35. Whereas the charge sheet it is said 32.
32.
And weight is also
33 point
court puts the question because court realize that there is a variation. So therefore the court question is very clear 33.39.
Yes, sir.
And
If-
every bag is 1
statement-
quintal.
Active statement, question number 6 also, he puts the same thing, it also transferred from the evidence on record there. On weight, meant the net weight of the seized rice came to 33.39 quintals. Active
Question
statement
number?
6, Your Worship.
Question number 6.
Question number 6. Let's give the benefit. What is the sentence?
3 months
Give the benefit and finish.
and 1,000.
Give that benefit. Other material maybe
And
there
some period has undergone, I think,
might have undergone
21
30
days.
Huh?
21 days. Under
21 days undergone. So sufficiently punished. Sufficiently punished. Right. The sole appellant in the
Judgment.
regarding what?
Regarding the sections of.
Regarding?
Section 7 of ECA, whether it is exact or not.
No, what is the proposition?
Position is that, Your Lordship, the two cases is there, Vijay Kumar Agrawala. And one judgment of this Hon'Ble High Court, Your Lordship. Orissa.
What does it say?
It's the saying about the studying about the storage and dinner, Your Lordship.
We are not going in that only the weight difference. I'll give benefit and finish. Right up.
Yes.
The sole appellant. What is his name? Sant Kumar Bhaduri has filed the present appeal saying the order and judgment, and order to take also, whereby the appellant has been convicted for offence punishable under section 7 for having violated what is that period. Is that period? That word. Clause 3 and subclause 1 of Orissa Rice and Paddy Control Order 1965. And sentence him to undergo RI for 3 years. And fine, any fine is there. SI for 3 years and to pay fine of rupees 1,000 and in default to undergo SI for the period of 1 week. The matter was this present appeal is pending since 1991. when the matter was taken up consistently, none had appeared for the appellate. Hence, Mrs. Is Rakhi Mishra, counsel who was present in the court and requested by this court, assist the court in the capacity of a history. She has given the consent on the basis of which she has been appointed as a magistrate by the order dated 14/10/2024. Mrs. Mishra has also filed a written note of submission, written note of submission. On behalf of the state, Mrs. Apat appeared and appeared. The prosecution story goes like this. Okay? The to substantiate this case, the prosecution examined 4 witnesses. PW1 and 2 are the independent witnesses, those who have not supported the prosecution case. Hence, the prosecution case only hinges upon the testimony of PW3 and 4. PW3 was the police official who has accompanied PW4. PW4 while while seizing while the search and seizure of the truck driven by the present appellant, driven by the present appellant, from which the from which 35 bags of rice, approximately 35 quintal in the weight, was recovered. The trial court, by relying upon the seizure list as well as the testimony of PW 2, 4, 3, and 4, have arrived at the following conclusion. Six, 7, and 8. 6, 7, and 8. Agreed by the aforementioned finding, which led to the conviction and sentence. The appellant has essayed, has filed the present appeal. Mrs. Rakhi Mishra, the level counsel in amicus curiae, has taken me to the evidence of PW taken me to the evidence of PW 3 and 4 and pointed out the glaring contradictions in the testimony. In the testimony, she has submitted that in so far as the recovery is concerned, it is seriously it is doubtful in view of the inconsistent version of the prosecution. Inconsistent version of prosecution. He stated that the story as emanating from the FIR, charge sheet, and the evidence of the witnesses reveals that reveals that the seizure itself is doubtful. Mr. Chapat, legal counsel for the state, however, relying upon the same set of evidence, has justified the reasoning recorded by the trial court, which led to a recording of conviction, which led to recording of conviction against the appellant under Section 7 of ECN. He submitted that the minor variations in the evidence of the witnesses will not inure to the benefit of the appellant, which calls for interference in the I have I have perused the evidence on record as well as in the light of the submission made by the parties. It is seen from the charge sheet that 35 bags of rice were seized from the truck which was carrying cement, 200 bags of cement along with the rice bags. However, after investigation, the charge sheet was filed by the investigating agency. In the charge sheet, it is very categorically stated that on 10/4/1991, at about 7 p.m., the accused person was transporting 32 bags of rice without any document in the truck number MP 26B oblique 268 with the view to sell it at the open market. Similarly, the evidence of PWD from the evidence of PWD, however, from the evidence of PWD and 4, it would reveal that both the witnesses have categorically stated that they have detained the truck and search was made. On the search, they found 200 bags of cement and 35 bags of rice being transported on demand. On demand, the driver, the bracket the appellant carrying, those showed the permit and other documents concerning the transportation of the cement bags, but could not show any document in support of the transportation of rice. Therefore, the PW4 seized the truck along with the cement and rice in presence of the witnesses, namely PW1 and 2. And prepared a seizure list as well. Insofar as the seizure of the rice bags are concerned, though it was claimed by the prosecution that it has been done in presence of PW1 and 2, but both the independent witnesses have wriggled out of both the independent witnesses have not supported the prosecution case, and they've clearly denied having any knowledge regarding such seizure. When the PW4 was examined, PW4 was examined, the court put a very specific question regarding the weight of the seized rice alleged to have been recovered from the truck. To that, the witness has stated that the weight of the rice is 33 quintal 39 kg. The relevant part of the statement reads as that para 3 of the process. That पूरा जाए para theta. Para 3 का पूरा लिख दो para 3. I then arrested in inverted commas. I then arrested the accused and forwarded him to the court in custody. I released the seized truck and the cement in Jima of Harish Kumar Tuli under the order of the court by the Jima Nama Exhibit 3. Full stop. I also released the seized rice in favor of the storage agent Mona Jhanchiwala under Jima Nama Exhibit 4. On completion of the investigation, I submitted the charge sheet against the accused persons under Section 7 of EC Act. Thereafter, to quote, underline, the total weight of the seized ice came to 33 quintals 39 kg, but not 35 quintals as stated earlier. Properly, perusal of the seizure list, Exhibit 1, also it reveals that 35 bags of rice alleged to have been alleged to have been seized. Each bag contains 1 quintal of the rice. Therefore, the total weight is ought to have been 35 quintal. However, there is
35 bags, ma'am.
35 bags, 35 quintal. And therefore, there is apparent variation in the evidence on record regarding the quantity of rice recovered. The charge sheet mentions 32 bags of rice, whereas the witnesses deposits that 35 bags of rice of 35 quintal in weight was recovered. However, when the court put a specific question to PW4, he has stated that the weight of the rice is 33.39 kg. Similarly, for the statement of the accused recorded under section 313 CRPC's seal in question while answering question number 5, yes, a specific question was put to the accused in question number 6, which is agenda. Question number 6. It also transpires from the evidence on record that on the weighment of the net weight of the seized rice came to 33.39 quintals. What do you have to say? Answer is I can't reply. This being the nature of evidence, the quantity of the seized rice being disputed, disputedly borne on record. I feel it's appropriate to extend the benefit of doubt to the applicant and benefit of doubt. Yes. The coordinator. Yes. Yes, next. I appreciate. Let me go. Item 6.
We have not taken the LCR. No. Still. Now he's still in service. For which still in service.
Yeah, I have
The
seen it.
appellant,
He is working as SA come
we have to take
six, na? Item kite?
6.
There are 2 accused, huh?
One is already done.
Sudhanshu Shekhar Behra
Yes.
and Saroj Kumar Pradhan. There are 2 appeals.
Yes.
Yes.
I take the LCR next Thursday.
Why today? What is the problem?
Mr.
The
Kotkia
matter
will
is-
Mr. Kotkia will. But-
Let him come. I'll go hold it. Let him come.
Okay. fine.
I'll hold it. Yes. Pass over. If he
I'll launch
can come,
after.
if he comes, then we'll see.
Yes, sir.
Yes. Item 7.
May it please your lordship.
Yes, madam.
Lordship, whereabouts had been called for in this matter and the
You've taken soft copy and all.
yes, your lordship.
Yes. Ready?
Yes, your lordship.
Proceed.
The appellant was 28 years while the commission of offence, your lordship. The convicted offence is that of Section 21B of the NDPS Act and 47 of the Bihar Excise Act, Your Lordship. The judgment has been passed by the learned Additional District and Sessions Judge Nayagarh, Your Lordship. The total sentencing is rigorous imprisonment of 1 year for 20B1 of the NDPS Act and 3 months for 47 of the Excise Act. The sentences were to run consecutively. So these sentences run to 1 year, 3 months, Your Lordship. The allegation against the appellant is that, Your Lordship, while the appellant was standing holding a bag in a bus stand, Your Lordship, the informant was a part of the anti-dacoity patrolling squad. So in the morning hours, he had just parked his vehicle along with others in the bus stand. So he noticed that this person is behaving a little bit suspicious. So he went and checked the bag that the appellant was holding, and he found that there was 425 grams of ganja that was there and 2 bottles of ID liquor, Your Lordship. Thereafter, he could not show any authority, and since this person,
20 grams.
yes, Your Lordship, for 25 grams.
Is there have you taken the defense of self-consumption?
Your Lordship,
Just the quantities suggest, along with the liquor, it might be for self-consumption.
Self-consumption.
that I would have brought that before Your Lordship for self, if that would have been taken as a plea. But that had not been taken as plea. Anyway, it has been pleaded denial because all the witnesses, except the informant and the investigating officer, all the witnesses, 11 witnesses were charge sheeted. Out of them, 8 were examined. Everybody except the informant and the IO, they have turned hostile, Your Lordship. So that plea might not have been taken because of the lack of evidence, Your Lordship. And also the our main contention is that even if the witnesses have turned hostile, Your Lordship, beside other discrepancies, the learned trial court has not discussed that why the person should face conviction even if all the Caesar and all the independent witnesses have not supported the case of the prosecution, Your Lordship. The only reason that is attributed is there was no mandatory requirement of section 42 and 50. And that is why, since there was no mandatory requirement of section 42 and 50, so that is why the whatever the PW1 and only PW1 has deposed, that has to be considered, and hence the person is appellant is
The
convicted.
entire case hinges upon PW1 only.
No, Your Lordship.
Hmm?
It will not hinge on PW1 because whatever PW1 is saying, he was not the concerned officer who could carry out the necessary formalities. So he was only the informant. PW8 is the investigating officer.
So let's see PW8 then.
Yes, Your Lordship.
Let's read.
PW8 is GR Mahapatra, Your Lordship.
This is a lady or lady was. Okay.
Shall I place the deposition? On 7/10/1995, I was SI of police attached to PS on that day. At about 5:30 a.m. from Nayagarh bus stand, ASI Ramesh Chandra Mahanti, this is the PW1, sent a written report to IAC Nayagarh PS through Constable 344 Sudam Charan Naik, PW2, Your Lordship.
He is not supported.
He has stated that he gave me a paper in writing.
Okay. Formal witness.
PW1 gave me a written report to me and hand over the same to IAC of Nayagarh PS.
To that extent.
That is there.
Yes.
That is there. Accordingly, I handed over the same to IAC. And as the report of a cognizable case under section 20 of the NDPS and 47A of Odisha Excise Act The IAC registered the Nayagarh PS case number 28295 and directed me to take up investigation. This is the report of R.C. Mahanti marked as Exhibit 1, which is the endorsement of IAC BP Das. He has not been examined, Your Lordship. As Exhibit 1 by 2 with his signature, I am acquainted with his handwriting and signature of the IAC. IAC noted this fact in SD number station diary, Your Lordship. SD number 139 of dated 7/10/95 and informed about the NDPS case to his immediate superior authority SP Nayagarh and sent extract of the said station diary to me. I was present at the time of making of SD entry and the dispatch of the extract of the same by the IAC Nayagarh, Your Lordship. The IAC has not come, Your Lordship.
Yes.
I came to Nayagarh bus stand along with BP Das.
I see that Das.
Yes, Your
BP
Lordship.
Das.
He's BP Das. He's not before this.
You understand?
I found the accused in dock was standing in the bus stand along with MO1 and he was detained by the ASI BC Mohanty PW1 along with APR force. I examined PW1 at the spot. I asked the accused his name and identity, to which he stated that he is Vijay Kumar Sahu, son of Gangadhar Sahu. Then I expressed my intention of search of the bag and person as suspected that some contraband articles were kept in that bag. I also gave him offer whatever he is intended to be searched before the magistrate or before a gazetted officer. So this is why the Section 50 compliance was sought for in the defense, Your Lordship, because none of this has been complied with. He's saying so, but
Is there anything writing exhibited?
Your Lordship,
Written.
No. That I could not find from the LCR subject to verification, Your Lordship. Before a gazetted officer, because none of them were gazetted officer. He expressed his willingness to be searched before a gazetted officer. Then IAC Nayagarh BP Das gave his identity to the accused, stating that he is inspector of police and the gazetted officer. Accused has stated that he has no objection if he will be searched before IAC, who is a gazetted officer. Before effecting search, I gave my personal search to the accused in presence of witness. Then searched the foam bag of accused MO1 in presence of the said gazetted officer and witness. And on search, I found one paper pocket containing ganja and 2 bottles of ID liquor. Before effecting search, I also called 2 independent witnesses, Chobbi Behra and Kalia Behra. This Chobbi Behra is PW6. He has been...
Kalia has not been.
Kalia has not been examined at all, though he was as a charge-sheeted witness, he was there. Then I called for one Lochan Sahu to come to the spot with weighing instruments to weigh the ganja, Your Lordship. This Lochan Sahu has again turned hostile. I'll come to that. To the spot with weighing instruments to weigh the ganja. The liquor was never measured. On which Lochan Sahu came to the spot and weighed the ganja in presence of the accused and witnesses. It was 425 grams of ganja. I demanded the authority of transporting contraband NDPS articles to the accused, but he could not produce any. I prepared 2 sample packets from the ganja containing 25 grams and the rest 375 grams of ganja was kept in a separate paper packet. I sealed all the 3 packets by affixing my personal brass seal, and before it, the wax seal was prepared in 3 separate white piece of papers containing the signature of witnesses and the accused. This brass seal has again not been produced as a material object.
57.
Yes, Your Lordship. 55, Your Lordship, that is. The wax seal were kept inside the seal packet. This is the paper packet containing the rest 375 grams of ganja. Ganja is marked as MO2. And these are the 2 bottles containing ID liquor marked as MOs 3 and 4. And MO5 is the paper packet wrapped in a piece of cloth duly sealed before the SDGM at the time of forwarding 2 sample packets to the state FSL BBSR on my prayer wide forwarding report Exhibit 3. After examining the 2 samples...
Brass seal not produced.
No, that has not been produced as a material object. There are only 4 material objects as noted by the learned trial
Let us
court.
see now. Let us see 55 and 57.
An officer in charge of a police station shall take charge of and keep in safe custody, pending the orders of the magistrate, all articles seized under this act within the local area of that police station and which may be delivered to him, and shall allow any officer who may accompany such articles to the police station or who may be deputed for this purpose to affix his seal to such articles or to take samples of and from them, and all samples so taken shall also be sealed with a seal of the officer in charge of the police station. So generally
Yes.
it goes by that the seal that is done,
Hmm.
that is also given to the GIMA is given to the independent witnesses, Your Lordship. So that when he comes to the trial court, Your Lordship, he will bring that brass seal and that would have been marked as the material object, Your Lordship. And Your Lordship, pertaining to this seizure, seizure and sampling
There
of
is a direct judgment, non-production of that brass
that
seal.
will not.
Do you have that judgment with you?
Your Lordship, I've gone through that judgment, but what I am contending here is, Your Lordship, that judgment was pertaining only when non-production of, only whether, if a case is relying only on the factor that there is a non-production of the brass seal, Your Lordship.
Yeah.
But here what we are saying is that is not the only factor. Cumulative effect of all the lacuna in the investigation and the proving beyond reasonable doubt that I was in fact.
This is one aspect of it.
Yes, sir. This is one aspect that we are contending.
See, non-production of the brass seal,
Whether it is
amounting to non-compliance of the procedural safeguard under 55
the fifth.
is direct judgment is there.
Your Lordship, again, another point which I could not find in the deposition, but the learned trial court has recorded is after the samples were produced before the magistrate has apparently opened the packets and resealed them. So
That's the finding.
that is the finding. So this is again does not Your Lordship, we have never come across that magistrate is supposed to open the seal and see what is there. He is only supposed to give a certificate.
Forward it.
He is supposed to forward it. But what the magistrate does here is on 7/9, he opens the packet, refixes it, and then says that you produce it before the court on 11/9, Your Lordship. That is not what.
Usual practice.
Yes, Your Lordship. Your Lordship, I'll come to that in the judgment, but I'll place this deposition first. Content found to wax. He says, Your Lordship, the chemical examiner found that the seal impression in Exhibit B was found to be similar with the lac impression in Exhibit C. But this lax impression had again not produced as MO, Your Lordship. After the sample packets are found to contain cannabis ganja, he also found contents of MO3 and 4 found to contain liquor and the percentage of alcohol to be 20% by the volume. This is the report of Exhibit 4 of the chemical examiner, Your Lordship. Till now, Your Lordship, the amount of liquor is unasserted.
Yes.
At this spot, I prepared the seizure list after making seizure of the ganja and liquor in presence of witness and the accused. Exhibit 2 is the seizure list, 2/3 is the signature. The seizure list was prepared in presence. Accused took his signature so and so in my presence, and his signature is marked so and so. After sealing the 3 packets of ganja, my personal brass seal was given in Jimma of the witness Lochan Sahu, PW7, Your Lordship. But this witness is again turned hostile, nor does he come with any brass seal.
Okay.
To the court, Your Lordship. Exhibit 3 by...
PW7.
Yes, Your Lordship.
What does he say?
I do not know Lochan Sahu alias Laxman Jao, Your Lordship. I do not know the accused who is in the dock. About 2 years back, once I was called to Nayagarh police station where the police took my signature in a paper. But I do not know anything about this case. This is my signature 2/3 on the paper. This is another signature marked as Exhibit 3 on the paper marked as X1. So our point is, Your Lordship,
He admits.
he admits that it is a signature. So had you given him the seal also, he would have admitted that in police station this was given to me, or in so and so place this was given to me. But that was never done. That is why he is admitting his signature but does not mention about the brass seal, Your Lordship.
He doesn't say anything about brass seal.
No, he doesn't say
Even
because it is
Jimma
not
or
given to
anything.
him. He's saying because, Your Lordship, brass seal when it is given to him, also physically it is supposed to be given and the signatures are to be taken. There is no reason assigned also by the learned trial court as to why this witness is to be disbelieved, Your Lordship. And the IO also says that the brass seal was given in Jimma of the witness Lochan Sahu, Your Lordship. These are the two paper slips which contain the signature of the accused and the witness marked as MO 6 and 7, Your Lordship. After making seizure of the ganja and the liquor, I handed over the 3 packets of ganja and 2 bottles of liquor in the Jimma of IIC Nagar PS to keep in PS Malkhana till its production before the SDG Nagar. I arrested the accused on 7/10/1995 at 7:30 a.m. After informing him the grounds of arrest, I forwarded him to the court on the same day. I also sent information to his father about the arrest. On completion of the investigation and perusal of the report of chemical examiner, I submitted charge sheet against the accused under section 23 of the NDPS Act and 47A of the Bihar and Odisha Excise Act. I've sent a detailed report about the detection of this case regarding search, recovery, seizure, and arrest of the accused to my superior authority, SP Nayagarh, Your Lordship. I have
Then
examined.
he says that he followed the procedure and all, huh?
Yes, Your Lordship.
Examine constables.
Yes, Your Lordship. He says that he has followed the procedure, but none of the procedure that he says is followed is supported by evidence, Your Lordship. That is what is our contention.
What PW
Like
4.5
on paper, everything has been done, Your Lordship. I have examined Constable 355 Bibu Prasad Mahapatra, PW4. Again, he is a police witness, but he is turned hostile. He stated before me that near the bus stand they found a man was standing holding a phone.
PW4.
Yes, Your Lordship. If we come to
PW5 also turn outside.
every witness, Your Lordship, PW3, 4, 5, 6, 7.
Their own police witnesses.
Police wit. And Your Lordship may listen to what, Your Lordship may hear to what PW4 is saying.
Why should PW8 will be believed? He is accompanied with these police people and all. And nobody is supporting him. 4, 5, 7,
6 also.
6. His version is the trial court has taken his version to be gospel truth and convicted.
Yes.
But some sort of corroboration has to be there. Why have you examined these people then? And he says that Das was the gazetted officer. Section 50 complied because you brought him and you asked him whether in the gazetted officer is here, will you give the search and seizure? He said yes, no problem, 50. But Das is not examined.
The accused voluntarily handed over the bag.
Das also not examined.
That is why section
Poor.
50 and 42.
Then the entire conviction has to be made on the basis of PW8 only.
And
He has basically written the judgment of conviction. Where is the search seizure document? Exhibit?
Your Lordship.
Has he signed? Das has signed or not? Search and seizure. Exhibit 2.
Page 44. only, 44.
Come to exhibit 2. See.
Lordship, may I read?
How VP Das has gone there? Any VP Das?
Bipidas has gone there being accompanied by the this.
He has called.
Yes, the PW8 says that along with me, Bipidas also came. He says that.
Well, before that, he knew that something is going to happen. You took him. Guest officer, he took him.
ରାତି ପେଟ୍ରୋଲିଂ ଡ୍ୟୁଟି ସାରି ଫେରୁଥିବା ବେଳେ ଆସାମୀ ବିଜୟ କୁମାର ସାହୁ ଗଙ୍ଗାଧର ସାହୁ ଓ ପିତା ଗଙ୍ଗାଧର ସାହୁ ପ୍ରଧାନ ରାୟଗଡ଼ ବସଷ୍ଟାଣ୍ଡରେ ଗୋଟିଏ ହୋମ୍ ବ୍ୟାଗ୍ ସହ ସନ୍ଦେହଜନକ ଭାବେ ଚାଲୁଥିବାର ଦେଖି ତାଙ୍କର ଧରିଥିବାର ବ୍ୟାଗକୁ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ତନଖି ନେବାର ସେଥିରେ ଗଞ୍ଜେଇ ଓ ଦେଶୀ ମଦ ଥିବାର ଦେଖି ଉକ୍ତ ଜିନିଷ ସହ ବ୍ୟାଗକୁ ଆସାମୀ ସହ ଜଗି ରଖି ଥାନାକୁ ଲିଖିତ ରିପୋର୍ଟ ଦ୍ୱାରା ଜଣାଇବାରୁ ଉପରୋକ୍ତ ମୋକଦ୍ଦମା ଚାଲୁ କରାଯାଇ ତଦନ୍ତ ସମୟରେ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ଗଞ୍ଜେଇ ଦେଶୀ ମଦ ପାୟାଯାଇ ଗଞ୍ଜେଇକୁ ଓଜନ କରି ମୋଟ 425 ଗ୍ରାମ ହେଲା। ସମୁଦାୟ ଗଞ୍ଜେଇରୁ 25 ଗ୍ରାମ ହିସାବରେ ଓଜନ କରି 2ଟି ସାମ୍ପୁଲ ପୁଡ଼ିଆ ସାକ୍ଷୀମାନଙ୍କ ଉପସ୍ଥିତିରେ ପ୍ରସ୍ତୁତ କରି ଅବଶିଷ୍ଟ 375 ଗ୍ରାମକୁ ଗୋଟିଏ ପୁଡ଼ିଆରେ ରଖାଯାଇ ସମସ୍ତ ପୁଡ଼ିଆକୁ 3ଟି ପୁଡ଼ିଆ ତା ମଧ୍ୟରେ ସାକ୍ଷୀମାନଙ୍କ ଦସ୍ତଖତ ସହ ସାମ୍ପୁଲ ସିଲ୍ ରଖି ବନ୍ଦ ରଖି ତା ଉପରେ ସାକ୍ଷୀମାନଙ୍କର ଦସ୍ତଖତ ସହ ଯୋଉ ସିଲ୍ ରଖାଗଲା ଓ ମଦ ବୋତଲର ମୁହଁକୁ ଯୋଉ ସିଲ୍ କରାଗଲା। And signature of witness is Kalia Behra.
Not examined.
Kalia is not examined.
And your
No, I'm asking something else. How the gazetted officer went there?
Your Lordship,
Was he-
PW8
see,
says.
come to pay, 50, section 50. Is it compliant? In its true spirit? Let's see.
Section 50 actually voluntarily handed over the contraband article.
Your Lordship, PW4 again denies that. Their witness says that we went to the bus stand and this person, this informant, went inside a bus and brought this person out. That is there by PW4, Your Lordship. I know the accused in the dock. About more than 2 years back, one day at 5 a.m., we reached Nayagarh bus stand after performing anti-dacoity patrol duty. At that time, one ORT bus came and stopped there. The PW1 went inside the bus to detect the transportation of contraband articles. He came out from the bus with a bag MO1 and this accused in dock was found standing near the bus.
That part is also.
And the learned trial court has not even considered this. He says that he came out with the bag, but the accused was standing near the bus, Your Lordship.
Bus.
And this accused in dock was found standing near the bus and
With a bag.
no, he doesn't say with a bag.
He come out from that bus with a bag.
No, he does not say. That is not there. PW4 he came out from the bus with a bag. He is the PW1, not the accused. The PW1 went inside the bus to detect the transport of a contraband article. He came out from that bus with a bag. He is PW1, who is the informant. And the accused in dock was found standing near that bus. So he came out with that bag and the accused was standing near the bus. He here is reference to PW1, Your Lordship. No, please, you can read the entire.
Yes.
तागुरु accused reference ही नहीं.
Which part of the
PW4 para
Let us
1.
come to PW8 again.
Yes, Your Lordship.
Let us see how does he say regarding the gazetted officer thing.
Gazetted officer is paragraph 3, Your Lordship.
3,
Paragraph 2 and 3.
2 and 3. Let us
Yes. This is the report of R.C. Mohanty, SI, marked as Exhibit 1, and this is the endorsement of IIC BP Das, marked as Exhibit 1/2 with his signature. I am acquainted with his handwriting and signature of IIC. IIC is BP Das. IIC noted this fact in the station diary wide ST 139 dated 7/10/95 and informed about the NDPS case to his immediate superior authority SP Nayagarh and sent extract of the said SD entry to me. I was present at the time of making station diary entry and the dispatch of the extract of the same by the IAC Nayagarh. I came to Nayagarh bus stand along with BP Das IAC Nayagarh.
Yes, this is what is the problem is. Come to section 50. Read section 50 now.
Conditions under which search of person shall be conducted. When any officer duly authorized under section 42 is about to search any person under the provisions of section 41, section 42 or section 43, he shall, if such person so requires, take such person
To
without
whom you are
necessary
want to
delay.
search person
To
without unnecessary delay
to the
to the nearest
officer.
gazetted officer of any department mentioned in 42
Section
or to the nearest magistrate.
nearest magistrate.
You should have taken him. Okay? If you can't take, what is the next?
If such requisition is made, the officer may detain the person until he can bring him before the gazetted officer or the magistrate referred to in subsection.
What is the idea of this provision is an independent gazetted officer or magistrate has to be there while search is to be made. But what have you done? You have done what? The same IIC who is entering the SD report and everything, and same IIC you are taking along with you. That's the idea of 50. And he is not even examined. You have deprived the accused to cross-examine him. How has he gone there? Was there any requisition? The mandate is you have to take that man to the gazetted officer or the magistrate, or otherwise you give requisition and please come here. That you didn't do. Rather, what you did is you carry with him the gazetted officer. Why have you done that? Is it the mandatory requirement?
Because he voluntarily handed over the bag.
No. See, therefore they say that if gazetted officer, the two independent witnesses has to be there. You didn't examine the gazetted officer. You didn't examine the independent witness also.
Exactly.
And one witness you examine, he doesn't support you. 50 is not to be complied like.
One witness examined.
One witness examined, but you deprived the accused to cross-examine the gazetted officer to whom you carried along with you. It is a kind of a situation the accused is to be produced before magistrate. No, magistrate is produced before accused. The reverse. You have done that. This is the over-enthusiasm in investigation. पेपर रे जहाँ भी कर दियो कन्विक्शन हो जाओ. This is not the idea of 50. Idea of 50 is to see that search is independently made. So see the safeguards, these are draconian law. The safeguards has to be, procedural safeguard has to be very scrupulously followed. Madam, you have to, in section 50, you have to give me a
Ye-
better
Yes, sir.
all judgments and the facts
Yes, sir.
terminating. So I want to write on
Your Lordship, all the compliances that have not been made and on the point of lack of.
50. You emphasize 50 because I
Yes,
have to write a judgment on 50.
Yes, Your Lordship.
Because see, this is not the idea of 50.
Idea.
You have to trace the what is the what was the
Legislative intent.
intent of section 50 and whether the intention is satisfied on the facts of this case or not. That is to be seen. This is very systematically it is said. You have to take him to the magistrate or the gazetted officer, or otherwise you have to requisition him to come. Please come. This is happening, and you can detain till then, till the magistrate comes,
If
the
you
gazetted
can-
officer comes. You can detain, and thereafter magistrate will come, and then you search. If he'll say that yes, I don't need a magistrate and all, then you have to give in writing a notice and get a consent in writing. Then in the absence of a magistrate also you can do it. This is the idea of this section. So you elaborate it.
Yes, sir.
11th with written note.
Your Lordship.
11th written note. Okay. Partly heard. Mrs. Mishra, counsel for the appellant, submits that she will to file a written note of submission and further argument on regarding the procedural compliance
Of section.
of section 50 and other.
Much advised.
Yes.
Item 8. Item 9.
Ninth, चलो करके चलो.
Item 10.
Yes. Yes. I have been telling you no paperwork business. You take it, the soft copy. You take it.
Okay.
Get the pen drive and take it.
Okay.
Get the pen drive and take it.
Only the petition copy is there, the file was not received. File was received.
Now everything is traceable in the webcom. You can take it. No problem. 10.
Item 10.
Eleven.
11.
Twelve.
Item 12.
What did I? 12. अच्छा, madam was arguing. Huh? अच्छा, sir, you appointed. Appointed here? No. Yes, madam. Partly thought of something. Yes. Yes, madam. Conviction under 323. Sentence.
Sentence is.
Allow him to in the PO Act is under challenge.
A PO Act has been given.
Yes, Your Lordship. That is under challenge.
What was the age?
At that point of time, 21 years, Lordship. Now the appellant is about 97, 28 ବର୍ଷ ହେଲେ 21, 49, Your Lordship.
Huh?
49.
50.
50, around 50, Lordship.
Yes, madam. Is there is this case is the case of acquittal? Let us see who is the injured.
PW4 is the injured, Your Lordship.
Let us see PW4.
4, Your Lordship.
PW4. Yes. What does he say? PW4. What is his name? Prabhat Kumar Pradhan. Huh? Let's see. PW4. Read PW4, madam. I know the accused. The occurrence took
Talk.
place,
The occurrence took place 2.5 years back at about 3 p.m. near Mohisa temple. At the time of occurrence, I was returning from
my house,
Bhagwanpur to my
which
house.
was
While I was returning on the road by the side of Mohisa temple, accused was threshing black gram on a piece of land close to Mohisa temple. On seeing me, the accused calling the fair names, so and so, why your father had come to our house to challenge us for cutting up a tree. When I protested, accused dealt me 4 to 5 blows
4 to 5 blows by
means of
Ukkunivadi.
Kunibadi. Yes.
I sustained injuries on my back head. I broke the right. I fell down on ground and lost my sense. I regained my sense at the hospital. I was examined by the police. I was also examined medically. Cross-examination. I was examined by the police on the next day of the occurrence. When I was in the hospital bed, I was assaulted by
Down to the lens.
on 23rd day of the month, and I disclosed
Ekkuda
about the
koncham.
incident to my brother Trilochan. 24th of that month, I told my brother morning hours I was in the hospital bed on the 23rd night and 24th morning. It is not a fact that I have not stated before police that the accused Prabhat abused me calling bad names and that I was assaulted by means of everybody. Till I lost my sense, I did 2 to 4 blows to me by means of Kunibari, and the first blow hit my only, and the first blow hit on my head. The first blow was to the left side of my head. The second was over the right side eyebrow. The other blows that were followed were on my back. Most likely, thereafter I lost my sense. And I cannot say if Prabhat did some other blows or not. I sustained bleeding injuries on my right side head and over left eyebrow. My clothes were stained with blood. The quarrel between the general caste people and on one hand and the scheduled caste tribe people on the other are still going on in our village. The people belong to horizon caste are annoyed with the accused. I belong to scheduled caste. My subcaste is Pano. The accused is a member of general caste. It is not a fact that the accused had not assaulted me. I have not shown my blood-stained cloth to the police. It is not a fact that I have falsely foisted this case due to the previous enmity between the general caste people and scheduled caste people. PW 4.
Yes.
PW 3 was the informant. PW 3 was the informant.
Period 3 is the?
Informant.
Yes.
Ravi Nayak is my brother. I know the accused in the dog. I have not seen the occurrence. My brother Ravi Nayak was brought to our house by Gopuri and Surendra Nayak about 2.5 years back at about 3 p.m. My brother had sustained bleeding injury on his head, on the eyebrow, and also on the back and other places. I lodged a FIR at the place on hearing from my injured brother. This is that FIR marked as Exhibit 1. This is my signature marked as Exhibit 1. I have written Exhibit 1 personally. I submitted FIR at the PS on the 23rd day of a particular month. Here my noted, it's a particular, it says that a particular month. When the FIR was in his hand, he says that it's a particular month.
Sorry?
The FIR was on 1994. But he says that I submitted FIR at the PS on 23rd day of a particular month.
Particular month.
But I do not remember the months.
That is very minor.
Whatever my injured brother told me, I wrote out in Exhibit 1. I was examined by the police after submission of the FIR. Surendra Nayak is my uncle. Gopuri is also my uncle.
When the FIR was registered?
399.
23.
30.
30
30th.
94.
Incident taken place on?
Occurrence 23/3/1990.
How the delay taken place 7 days?
There is two occurrences. First is the theft, that is on 8 a.m. and the assault is on at about 3 p.m.
On the 23rd.
On that same 23rd p.m.
But why the FIR was delayed?
That part is not discussed. Either in the prosecution side or in the deposition mechanism for surveillance.
PW8 is eyewitness. Who is the IO?
Item 10 years, maybe 10 years.
So the FIR is delayed. How is it?
I was attached to Jagannath Prasad Outpost as ASI on 30 March 1994. On that day, at about 8:30 a.m., complainant Trilochan Naik, son of Anand Naik of Luniati, presented a written report to me. This is that written report already marked as Exhibit 1. The written report revealed commission of a cognizable offense under section 341, 323, 325 IPC and under section 3 of the Assistant Act 99. I entered this fact in the station diary by number 476 dated 30/3/1994. Thereafter, I sent the written report treated as an FIR to OIC Fatehgarh PS for registration case. Pending registration of the case, I took up investigation. In course of investigation, I visited the spot on the same day at 9:45 a.m. The spot is in front of the goddess Mahishasuri temple on the Gram Panchayat road, running from Bhagwanpur towards Luniati. I also examined the witness, including the complainant. The complainant was in fact examined at the outpost. I have not made any attempt to effect seizure of the weapon of offense. I cannot assign any reason. Again says, I have searched the house of the accused for effecting recovery, but I have not mentioned the fact in the case diary. On the same day, I issued injury requisition in favor of injured Ravi Naik to the medical officer, Hon'Ble Government Hospital, who had already appeared in the said hospital for his treatment since 24 March 1994.
See, delay is not explained.
Yes, sir. That pan, my learning center.
No, come to page 51. He said, according to Exhibit 1,
Yes, sir.
the occurrence took place on 23/3/1994. The informant lodged Exhibit 1 on 30th March 1994. There was no reasonable cause for delay in the submission of exhibits also at the outpost. All the witnesses have examined shown.
That part to, you need to kindly digital page 25 per also.
20?
Digital page 25 per also. In the affair, column number 8 has reasons for delay in reporting the complaint is clearly stated in the affair and so also due.
What is that affair?
Due to treatment of injury, that has been clearly mentioned in the recital of the affair and the column in the affair and so also corroborated by the PW 5 and 8 in his cross-examination, Lordship.
Where is it due to?
Lordship, digital page 25, Lordship.
Where
Reasons
does
for
it-
delay in reporting the complaint informant due to treatment of injury. That is in the affair column. And recital, the affair is clearly mentioned, Lordship, that is last 3 lines above. ଆଠପ୍ରହାର ସେହି ସମୟରେ ଗୋକୁଳି ନାୟକ ଏବଂ ସୁରେନ୍ଦ୍ର ନାୟକ ଉପସ୍ଥିତ ଥିଲେ। ବର୍ତ୍ତମାନ ମୁଁ ଗୁରୁତର ଭାବରେ ଆହତ ହୋଇ ଖଣ୍ଡପଡ଼ା ସରକାରୀ ଡାକ୍ତରଖାନାରେ ଚିକିତ୍ସା ଅଛି, ତେଣୁ ରିପୋର୍ଟ ଦେବାରେ ଡେରି ହେଲା। That is the clear mention in the affair, delay in lodging the affair. And that was corroborated by the evidence of the eyewitness PW 8 and as well as the injured, your lordship.
But they have said that the incident had taken place, but
That-
haven't said. See, the doctor says that it was a medical legal case, but I have not.
Immediate
found-
should have been lost, that is there. But the grounds of delay is clearly elaborated.
PW3 is the informant. He doesn't say anything.
PW3, your lordship, clearly. Yes. Lordship, PW3, my brother has sustained bleeding injuries on his head and his eyebrow and also on the back other places. PW3, Lordship, Tillochon Naik, Lordship. Please.
Under the examination of the accused by the doctor,
He says that whatever my brother, injured brother said, I have written it.
Right.
And the same time he says that after he sustained injury, he was brought to the house at 3 p.m.
Also.
under
Mm.
the cross, the medical.
After the prosecution.
Date and time of exam, 24.
24, I know that. I've seen it. 24, I've seen it. I've seen the doctor also, Dr. PW7.
PW7.
PW7 says that it is a medical legal case, but I have not told the police.
But I am to that satisfied also I am placing the
Huh? Or 24th it is done means 6 hours, obviously.
to that aspect I am placing the cross-examination part of the PW8, your lordship, why the delay occurred in lodging the affair is clearly given. And my learned senior sister, but perhaps PO Act no they clearly
I just see, despite PO Act, he
No, I am-
challenging means there must be some kind of
I am placing the PW
is a case of acquittal maybe therefore.
No, that's what I am saying. Only I am placing the PW8.
Just check it up, I'm just coming.
That's it.
Yes, madam. See, the problem is the injured witness, the independent witness 2 and 8 are consistent in their statement and which found corroboration with the PW7, the doctor. Apart from minor variation here and there, the major point which you have pointed out is regarding the delay in the FIR, but delay is somehow explained in the FIR itself. Medical?
Medical.
Here.
Exhibit 1,
That is done on 24th.
exhibit 2.
Done in 24th. Yes.
The above noted person reported to have certain bleeding injury in his head and near the eyebrow, incident by means of a lathi by Prabhat Kumar Pradhan of his village. And he has been already under treatment of your hospital. Please examine him and opine as to the cause and nature of the age of cause, nature and age of the injuries. Thereafter, date and time of the Adam, 24/3/1994 at about 5 p.m.
That's there.
23/3 at about 3 p.m.
3 p.m. You are saying 6 hours?
See, he says
These are 1-2 hour here and there.
He said date of time of exam is 24/3/1994. And in the affairs, he explains that he took the injured immediately to hospital. Therefore, he is late. But he took the injured after 1 day. 23 occurrence is 24 is hospital.
But he is the government employee. Huh? Is this appellant is a government employee? Huh? Then probation is given. Why unnecessary interpret? Not necessary. Probation. Not a government employee. Nothing is there on record.
Rightly, Learned Trial Court has granted the PO appeal to appellant. In the ground, PW for the injured and PW 2 and 3 the eyewitness is clearly corroborated the evidence led by the PW 4 year also. And delay in lodging of FIR, my Learned sisters seeking the delay. Delays have already been explained by the PW 8 in paragraph 5 of the prosecution and PW 10 in correspondence of the paragraph 5 of the prosecution.
Explanation is not corroborated with the medical report.
But the trial court is also has written a very sketchy no evidence, nothing.
The
There is explanation, but the explanation is not corroborated with the medical evidence.
Very sketchy. Okay, let's see. This. Okay. Let's replace it. Okay. ठीक है. Is there, sir, is there DVT?
Item 19,
19, na? Yes.
324, 6 months, 294, conviction 324.
Appellant number 4 died, huh?
So, report that. That is the report,
1, 2, 3, 5.
madam. Friends, in the year 1999 is done. As well as that, Buffalo, they received the message that the Buffalo damaging his crop plant and one went there and give for yourself.
Hmm.
Six months, 324,
6 1.
324, 6 months and the 294, 506.
Conviction.
Sorry, 500.
324, 294, 34 IPC. Convictions on
324,
294,
294 and
35.
34. Okay.
Substantial
Sentence
sentence
is
is
6
6
months.
months, 6 months and 500 rupees fine.
Undergone period
2 days.
2 days. Shall I grant provision? Huh? Give provision. Okay, pure. Pure. Pure.
Madam, 20 minutes.
2 days undergone, huh?
13, because I said 30.
Let us see. Undergone period, let us understand.
13 time arrested, 14 time.
See the final form. Final form is arrested on 13/10/99.
13/10/99.
Arrested.
13/10/99 arrested.
Bail bond is on 17th August 1997.
17?
August.
17th October.
17th August.
Oh, what's the good? Year?
Hey, proceeding just see.
Page 5.
Difference.
Bail bond in the subject.
Year देखना 99
Page 511. The bail bonds are there.
हाँ बुझे कितने को year
90, 97 ना
2009.
ऊपर तो डेट हो गई
2001.
You see the bail bonds. 17th August bail bond.
17th August.
2001
5 April
Gokulo. Let us see Gokulo. Gokulo 17th August.
Sankar arrested on
Take it.
13/10/1999.
Arrested on 13th. Huh?
Sasanka
And
Sankar.
see,
Gokulananda.
Ganapati Jana. Ganapati died. Okay.
Ganapati is dead.
Died. And Gokula Jana has given bail bond on 17th August.
Yes, sir.
17th August. Gokula 17th August 99. Gokula. Sorry. তারপরে গোপাল
13/10/1999.
also 2001 bail bond is 2001. When is the judgment? Judgment is judgment dated
Bail bond is dated 17th August 2001.
Ganapati Jala.
7th July.
Gokulananda is on 17th August 2001. And Gopal is on 17th August 2001. Sasanka Sankar Raut on 17th August 2001.
11th August bail is granted by this court.
Yes, sir.
They were
On 17th August, they were released on bail.
they released bail.
Arrest taken, sir.
They were in custody or what? They
Pardon?
were in custody. Till
They
that
were
time,
in custody. Your Lordship.
from the date of judgment.
13/9,
13
1999, they got arrested. Thereafter, they released on
Bail on
17 August 2001.
17th?
August. As for the bail bond, they were released on 17th August 2000.
This court देखो order sheet है ना order sheet देखो
No. Judgment is impugned judgment is
Also 2004.
they have undergone
Judgment
about
2004. 7/7/2004.
so they have already undergone for more than
13/10 they got
Eight.
arrested. On 17/8
about 10 months, more than 10 months.
PSCC Act was there now. Acquitted.
Acquitted. They have already undergone then. They have already undergone the substantive period. They see the proceeding, just see the proceeding in the trial court proceeding.
yes, Mr.
17.
Page 5 of the liquid brief resolution. Order number 3, 17/10/2001, accused person
Accused
person Sanatan Rauto and some Palei are absent.
Are
The defense is so-and-so. The accused person so-and-so to continue on the bail. The bail is allowed, put upon so-and-so for occurrence and bail of the other accused persons.
no 28/8/2001 proceeding just read.
Letter noting the communication statement
Commitment.
explanation. Commitment. Yes.
Statement.
Explanation. The delay in commitment and the case records GRX 1 so I received from the SDGM Jyotura. Accused person Sankar Shashanka Sekhar, Gokulananda, Sanatana, Kunapalei, Gopala, Rauta,
All the names.
All the names. Okay. Are
Are committed to the court of sessions.
Sessions. Yes.
Koraput of at
To face their trial.
to
and
face
so-and-so.
their trial
Yes.
for an offense under section so and so.
Yes.
The
The
committing
magistrate
magistrate reports that
the accused person
the
are on bail.
accused persons are on
On
bail
Yes.
and they are directed
to appear before the court on
before
14/9.
the court on 14/9/2000. Then yes. See, in the bail bond, if you see, come to the bail bond.
17/8.
17. In the bail bond, it is written 14/9/2001. In the bail bond,
The appearance date.
appearance date.
Yes.
So that
So they were released on 17/8/2001 year.
then they have undergone
More than 6 months.
November, December.
13/10/1999 they got arrested.
Then how many months?
13/10/13/11 13/12.
November, December, January, February.
10 months. 6 days less than 10 months.
10 months, 4 days. 10 months, 4 days.
Yes.
10 months, 4 days. Undergone. Already undergone. Period.
Next item. Small matter.
Yes.
Item 20. Conviction under section Only fine will happen.
Hmm?
So section 294, 506 will happen. And 86, 186. 294, 506, 186. Acquitted from 3110 is there. Police.
Only
constable-
fine has been
Informant
awarded.
will have.
Only fine.
Only
Fine.
fine.
But in the case of acquittal.
Acquittal, then you want to argue, then I'll hear.
Well, only whether.
Fine of how much? 500.
1,500, 500.
But
Yes.
there is PW 3 the informant in the constable will have. Allegation is that the constable party, the police party, putting one ASI Bhoi Miller, where they
He was engaged at the examination center to see the law and duty in the class 10 examination.
Hmm.
The accused person assaulted him and abused him in filthy language.
They are abused. They said assault part is that. Only abuse. They said
That is
abuse.
PW3.
PW 3, you'll speak as PW 3 stated.
They are students.
No, they are outsiders. But PW 3 stated that the headmaster has seen all these things, but the headmaster does not support the case.
Let us see. I know
PW 3 you'll
PW
speak as.
in the top.
6 and 7 are the eyewitnesses to the
I was,
occurrence
uh,
apart from the
yes.
PW3.
But they are PhD.
PW 6 and 7.
हाँ, PW 3 है.
No.
PW 3 को इला है.
ASI. I am reading 3.
हाँ, PW 3.
ASI.
At that time, the headmaster Tukla High School, who was hearing all these words of the accused persons, encouraged me doing my official work peacefully. Or PW 4 is the headmaster.
Let us see. Where are you reading?
Miller, page 2 of the
Indian police people cannot.
deposition Miller. Paragraph 1, page 2, in the middle.
Page 2.
At that time, the headmaster,
Hmm.
at that time, the headmaster Tukla High School,
At that time, headmaster Tukla High School.
Miller. Tukla High School
was
was hearing all these words.
These words. The accused persons encroach on my official duty work peacefully. The accused persons use abusive words against me, and I being a public servant, so on, so on. Take care.
Miller. PW 4 has not supported, the headmaster has not supported.
PW4, what does he say?
PW3 is the victim. PW 6 and 7 are the eyewitnesses to the occurrence.
1 minute. PW4 from 8. There should be recognition to the illegal act of the center. Therefore,
The
the
equation
police
from
was
the
available in the school.
police person,
There was a lot of halla outside.
There was a lot of
school.
I was not aware
Not aware.
as to what happened at that time, because I was busy.
Because
I did not have
I do not
opportunity inside or outside.
And 1 6 and 7 are
He
eyewitnesses.
was a petition for Acha. Hostile. He was hostile.
भाई ठीक.
Yes.
One PW8 also, the PET Miller School, independent, he also not, doesn't support the prosecution case.
He was there in the spot. Was he there?
Miller, the
PW8.
teacher. One system statement.
He says I was absent. I was absent on the day
said.
examination was going
Why
on.
was absent in the examination?
Was going
going off? He was not there, he said.
Was not.
And PW6 and 7.
I'll start with the PW3 first.
PW3?
PW3 was the victim in this case.
Yes, PW3 I read it. Which part you want?
All three are constables.
He has, PW3 has given a detailed count of the
He is a
incident.
victim and he has.
What is the corroboration? He says that the headmaster has seen it. Headmaster says no, nothing has happened.
PW 6 and 7. I'll start
6
with
and
PW
7.
6.
Let us see
They are constables.
what they say.
PW 6 Your Lordship. Sadananda Sabara.
Narayan Singh. Maji and Pundan and so on.
So bottom page is Your Lordship.
The duty of the school and
An officer, namely Mr. Bhoi, ASI, was also on duty on that day. The accused person came and abused the Lakshman Sabara, the informant, and abused like Sinifa and threatened him to take away his life. Again at 1:45 p.m., they came to the school premises by a motorcycle, also threatened the informant by saying so and so. The informant intimated this back to the police station and submitted report on so and so.
Omnibus, sir.
I know the no omnibus.
Hmm.
I know the accused persons prior to the occurrence. The occurrence took place in front of the office of the headmaster, Tukla High School. Some of the guardians of the students are also present. So on so.
That nobody has been named.
The accused versus.
I think
So
PW
it's
7.
And it is
From
not
the
fact that-
headmaster office, na, but
There is no suggestion even that he was not present at the spot or he has not witnessed the
And what 7 says?
7th.
7. Another constable.
The Vrindavan Purohit. I know the accused person are Lakshman Sagar, one of our staff. On 13 to 2000, the matriculation examination was going on in the Tukla High School and we were on duty to check malpractice, etc. We found that the accused persons were present inside the school campus, which was not allowed by the ASI of police. Mr. Bhoi directed the accused Lakshman Sabar, Surendra Behra and Rajendra Behra to remain outside the campus. These are the present appellants. Lordship. At this, the both accused persons started abusing
Where
Lakshman
he has
Sabar.
taken the name?
Lordship,
The
PW
accused
7.
versus.
PW 7. Lordship.
This incident took place at 11:20. Both of them also.
We found that the accused persons were present inside the school campus, which was not allowed by the ASI. Mr. Bhoi, he directed the accused Lakshmana, Surendra Behra and Rajendra Behra to remain outside from the campus. As at this, both the accused persons started abusing Lakshmana Sabar, one of our staff, who was asked by the ASI of police to drive both the accused persons. They uttered the word so-and-so towards the Lakshmana Sabar. The incident took place at 11:15 a.m. Both of them also threatened that they will take action against the police officers. At about 11:45 p.m. on that day, the accused persons again came to the place of occurrence by coming with a Rajdut motorcycle and threatened the informant to assault him and also abuse him like so-and-so.
PW3 said that only Rajendra Behra was there at the first instance, 11:40. But here she said both are present there. So there are so many infirmities there.
Nee, what are the utterances? The utterances he says.
There's a 3 SC
Three
Act
SC
is
Act
not
is
there
not good.
anymore. It's confined to 294. So
And that ASI Miller was there, he has not been examined. And the guardians, they are present also, nobody has been examined. Clear case of police.
What 3 says?
And when trial court has discussed also paragraph 10, can you see? Paragraph 10 of the judgment.
They see PW 3,
6,
6 and
7.
7.
Okay. These are the
Witness to the occurrence,
police
3 is
witnesses,
the
those have
yes.
separate the case. according
Yes,
to you.
sir.
And 8.
It was not present, so
No, anyway,
he corroborated
principal
doesn't
4,
arise.
Principal is the 4. Principal is 4. And the other witnesses, all the private witnesses are supported.
They're not supported.
But see 3, 6 and 7, just see. What are the utterances according to them? He scolded saying so and so. PW3 says, okay?
Yes.
In para 1 itself.
Yes.
And PW6 says something else. Something else. And PW7 says something else.
Fine.
Just see, something else. Let us see
The matter, they have also
whether
admitted that the
these
matter-
things are put to accuse. Come to 313, question 3. Question number 3.
Yes.
This is what the question is.
Mhm.
This is the way.
6 and 7
With
come
the
out
settled
like,
position of law, you don't put the incriminating materials to the accused. How will you use it?
it is stated. I mean,
In one go. Further, it is the evidence of PW1, 3, 6, 7 that you abuse PW3 by saying so and so. What was said by them? All 3 have said different things.
Yes, sir. So PW3 doesn't say particular words. PW6.
No, PW3 said, just see.
Yes, sir.
Along with this, what else?
Yes.
Just see.
Yes, sir. The
PW3,
the third
in
line.
first
from-
paragraph itself.
Third
it
line
says,
from the bottom. Abuse is there, the particular words are being used.
No, that's it. See, if you have to scrutiny saying this, he has scolded.
No, there are
And all of them are different story. And
there are contradictions. There are contradictions, Your Lordship. The particular abusive.
When independent witnesses have not supported your case,
Yes.
only three police persons.
Official witnesses.
Then
Yes.
Evidence. Okay.
Reports, all matters are there, it can be disposed of as it is.
Which item?
Item number 14.
Where I need not write judgments. Small matter I can do. it,
Small
because
rights.
Only 3 matters
Yes,
reserved.
there are small items where it can be disposed of on PO or.
Yes, to me.
Item number 14.
14, yes.
It's a case of 326. But PW1 has not stated, doctor has not stated the injury is grievous or simple. And sorry, he has stated the injury is grievous, but no X-ray plate has been exhibited. My lord must have seen that judgment of Honorable Justice Israni. And also 3-4 days back. PW1, madam.
Yes.
The 3 years.
Inside wound.
3 years.
Inside wound.
It can be converted to 323 or 324 and in the absence of the X-ray plate, it cannot be opined that the injury is grievous or simple.
Now, where does he say that it is grievous?
My lord, in the very first. My lord, incised wound 6 inch into 2 inch into 1 inch over right side of scapula. The injury was grievous in nature. Could have been caused by
grievous in nature.
My lord. But this opinion is not based on the report. Rather, he says that he was an indoor patient for 10 days. The peculiarity of the case, my lord, which I don't know whether it has been recorded wrongly or, my lord, that is, my lord may see the evidence of PW5 IO. The occurrence has alleged to have been taken place, my lord, on 12/5.
12/5.
My lord. But the IO says he examined the informant on 3/5, arrested the accused. My lord, may see PW5.
Maybe that is 13.
My lord.
Maybe that is 13.
Yes, if that is 13. Forwarded the accused on 4/5. So
Maybe that is 14.
certified copy, my lord. I have certified
One,
copy.
one maybe. Let us see.
That is there in the original also 3/5.
In this case, what happened? There is initially PW6 is the SI, the outpost has received the complaint, and PW5 has filed his charge sheet.
What he says,
No,
I understand.
that part I am keeping in mind.
The incident has taken place on 12th of May.
95.
I examined the informant and witnesses. They did this spot arrest the accused on 3/5.
3/5, yes.
But
And forwarded
and
4/5.
to the court on 4/5.
Let us see the exhibits.
My lord.
Exhibits, let us see. Exhibit to forwarding report and all.
Forwarding report has not been exhibited, my lord. Then instead of going to the merit of the case, I said, my lord, X-ray plate has not been exhibited. The judgment of this honorable court is there, my lord, where in the absence of the X-ray plate,
no, that should more digital please come and let to bring to at least notice of the honorable court. Arrested on 3/7.
my lord, may kindly see this also. I think somebody must have shown in the midnight.
No, see, the doctor, when the doctor has examined.
Doctor is the PW1 year old, sir.
Come to the
10/5/95 I was examined by
10/5?
10/5/95 I examined the beginning of
11/5.
But the incident taken place on 12th, no?
Incident in 10/5. Occurrence has happened in 10/5/95 probably.
Yeah.
Exhibit 2 is the affair, also.
He received the affair on 12
The incident happened when? When you said?
Occurrence was happened on 10/5/95, Your
The
Lordship.
doctor has given a clarification as because the injured has said that he has already, they have already taken care of the police station. I have not reported to the police.
In the medical legal case, you have to report.
Yes, he should have reported. But let me see the cross-examination. The injury mentioned in is possible if a person falls from a height on a broken glass height. I mean more than 10 feet. It is not a fact that I examined the injured before receiving the police requisition. Well, got it? I have not mentioned the time and date of examination of the injured in the report. It is not a fact that the injured was not identified to me by anyone. I asked the injured and he said that the injury was caused by a sharp cutting weapon by the accused. I did not send the information to the police because the injured and the other persons told me that they have already reported the matter. But IO says he got the information on 12th.
What happened? Kindly glance the PW 5, Your Lordship. The ASI of the outpost, Your Lordship. What he has stated, Your Lordship. May I read the digital page 45, Your Lordship? Yes. On 11/5/95, I was the ASI of the Nuapada police outpost. That day, I received a written report from the one Ras Govind Patra. I treated the said report as affair and they started investigation. I forwarded the report to the OIC Nuaga PS.
Where are you reading?
I am reading the digital page 45, Your Lordship. That is the
Evidence of?
PW6, Your Lordship. Paragraph 1, Your Lordship. On 11/5/95, I was ASI of the Nuapada police.
What do you want to say?
The incident occurrence was happened on 10/5/95. The affair was lodged on 11/5/95 before the Nuapada police station. And after the ASI registered the affair, treating as affair, thereafter forwarded to the nearest police station, Nuagam police station, Lordship. The PW5 was the charge sheet, filed the charge sheet, and OIC of that police station, and she stated that I have received the complaint from the outpost of the Nuaga. That is why I am bringing to the notice of the court. That is the intention of the submission before the PW, the deposition of the PW6 charge.
I examined the informant. It cannot be.
I'm not. I'm reading in full, Lordship. I'm placing the entire evidence of the PW5 and so also PW6 also. Se କହିଛି ମୁଁ ଥିବା ପର୍ଯ୍ୟନ୍ତ କହିଲି ତାପରେ ହ୍ୟାଣ୍ଡ ଓଭର କଲା ପରେ ସିଏ ରିଇନଭେଷ୍ଟିଗେସନ କରିଛନ୍ତି ମାନେ ଇନଭେଷ୍ଟିଗେସନ କରିଛନ୍ତି that is there Lordship. ଯାହା ଅଛି on record I could not
I examined the informant. I examined the informant and witnesses, visited the spot, arrested the accused on 3/5 and forwarded on 4/5. It cannot be an original says so.
The originals are there. Where is that?
Again?
Forwarding report. Where is that forwarding report?
Forwarding report. See,
Is there? Let us see the case. That must be a typo. His diary starts from 11.
11.
So then, where is the question?
Case diary starts 71 of the PDF. PDF page 71.
FIR itself is 11/5/2095.
Before the registration, the injured was examined and doctor says on being questioned, injured said they have taken care of.
May bring to the digital page 27 and 28 the
But I
FIR.
see the requisition. Page 50, madam. PDF page 50. Requisition is on 11/5. The report is on 10-5. How?
No, report is 11.5.
10-5. On 10-5, I examined. Okay, the
ମୁଁ ତାର ଆପଣ digital page 28 ଟା ଦେଖିଥିବେ ନା ଦେଖନ୍ତୁ କାହିଁକି टाइम डेट ऑफ occurrence वेडनेसडे 10:95 4 PM
इंजुरी टेसल के पे रहे 11-5 10 ना
हमारे ऑब्वियसली हो 11:05
11-5 इंजुरी था मतलब I330 ने पता रहा है 10-5
The incident happened on 10th July, 10th May. 10th May.
Acquisition is on 11-5. But the doctor report which has been taken note of is on 10-5.
When you are arrested? 12.
My lord.
As per 12.
चार्जशीट में भूल लगा है 3-7 3-5 और
ଅଲଗା କୋଉ କେସ୍ ରେ
ଅଲଗା କୋଉ case ରେ
ଟ୍ରାଫିକ୍
ଗୋଟେ ହେଇଛି କି
ପିଏସ୍
କଣ?
68 ରେ ଅଛି ଏଟା ନୁହଁ
3-7 ही लगा है
13 arrested.
ଆଜ୍ଞା
13 arrested.
मतलब ये केस रे केस बैलेट में सी चार्जशीट रे फाइनल फॉर्म रे देखो जे अरेस्ट ऑन 3-7
That is there in fact.
मतलब
13th.
13/7
3-7 95 लिखा 03 लिखा है
03.
हाँ
0304 ବି ଲେଖା ହେଇଛି କିନ୍ତୁ
And if 0 would not have been written, at least you would have said a typo. What to
Certified मतलब ଭିतरକୁ ଯାଉନି at
Huh?
this stage मतलब खाली I am on evidence of PW5 sorry PW1
Let us see the forwarding report. I'm not able to
Forwarding.
because you got you furnished the bail bond on 4/7/95.
47
Huh.
47 को ଆସିଲା
4/7 meaning
ଅଟଳା
you
ଯଦି
remain from even if you take it from 13th 7.
15-7
that is arrested on 4795 lordship that is in digital page 3 your lordship
Hmm?
digital page 3 your lordship order number 3 dated 4795 accused Jyotia alias Krishna Chandra Maharana that is the present appellant
Hmm.
son of late Shams Maharana of so Nuagan district Ganjam is reproduced in court by the escort party along
All
with
the typos.
forwarding report of the YC Nuagan PS with his enclosure. The accused compares on the link police value.
ଅର୍ଡର sheet
It a trial court order sheet special judge number
47
charge sheet आपको charge sheet ହେଇଛି
Four-seven he was allowed to go on bail.
No, in the statement, what he says, he arrested on 12th.
Along with the forwarding report on 4-7. The accused complains of no ill treatment, the police while in custody.
I think the same day he got bail.
Same
Arrested,
day.
arrested and got bail.
Same day. ପିଲାମାନେ ଦେଖୁଛନ୍ତି 2 ଦିନ କଷ୍ଟଡି ରହିଛି ସେମ୍ ଡେ ଯାଇଛି
Yes, same day.
ହେଲା what I am praying my lord
Hmm.
in the absence of the X-ray report if it can be converted to I have given a judgment my lord
Hmm.
of this honorable court
Yes, in the
where the case has been converted to 323
No, here in this case, he says that there was no opinion given whether it is
No,
simple or.
X-ray plate has
He
not
says
been.
that reserve till the X-ray report is there. The
Here,
X-ray
here
report
the-
was not placed. So therefore, court said
Here
that
the doctor who has examined, he says injury grievous. But from on which basis he could know? Because definition of grievous injury mallet must be in custody as an indoor patient for 21 days, some like that mallet. Here he in custody, he was in hospital for 10 days. If that would be taken into consideration, so Peters.
opinion of the doctor recording the grievousness of the injury will be taken to be the simple one, and the accused in that case was held liable for 325, but 323.
NOC would have looked. In these cases, it has been held that the absence of X-ray report and the opinion of the doctor recording the grievousness of the injury will be taken to be simple one, and the accused in that case held liable not under section 325 but under 323.
It is not in this judgment. It's not clear whether the doctor has said it is grievous.
That observation is there, my lord. Doctor recording the grievousness of the injury will be taken to be simple in the absence of X-ray. Here the fact has not been mentioned.
But because the doctor says that he has reserved his opinion
Injury,
till the X-ray report is
My lord,
placed.
in these
X-ray
cases,
was not.
in these cases, been my lord, in 1977 CLT and 1970 CLT, note 39. In these cases, when means to these two cases, it has been held that the absence of X-ray report and the opinion of the doctor recording the grievousness of the injury will be taken.
What was the injury in that case? Two injuries were there.
And two injuries on the person of PW1, swelling and
PW.
deformity with deformity over
doctor-
his right hand. Other injuries are abrasions.
Doctor is PW4, na?
Doctor is PW 6, PW 1.
One. One injury, my lord, on the scapulary.
Incise wound in 6 into 2 will also from the right side of the scapula. The injury
Scapulary.
was grievous in nature, could have been caused by sharp cutting euphonum.
But what made him not to go for X-ray and
Has he asked for X-ray? No.
no? I'm not brought his records.
He's not saying X-ray report is required.
Again?
He's not saying that the X-ray report is
No.
required. For every then if this is to be believed, then for every grievous injury of this
X-ray is a
nature,
must.
X-ray is a must.
Other judgments are there of the apex court also. But
Get these two judgment at least. Anant Charna Behra and Duryodhan Varas. Get these two judgments. Let us see if grievous nature, then X-ray is mandatory. Then otherwise it can be treated as simple. We can treat it as simple.
With regards
323. Instead of 325, we'll convert it to 323 and probation of offenders. If that is to be, if you get the after lunch, you get these two judgments. Okay.
Item number 31, my lord. 306-498A. Here the report of the government advocate, my lord, that addressee appellants are not available. If the record will be believed as it is, appellant number 2 would be around 89 years and appellant number 1 is 57 years. It's a case of 498A and 306. I think, my lord, whether it can be hard in the absence of them or it can be given to my associate, my lord.
31. Item 31.
My lord. Because the report is that whereabouts not found by the police. Pandey, they must have left they were working in steel plant, it seems. And
What
it's a
rules?
matrimonial offense.
Okay.
After retirement, he must have left Rourkela. I contacted
You don't have any information.
I contacted 2-3 lawyers of Raurkela because the lawyer who was conducting the case is no more. So I contacted some lawyers. They said we are not getting him.
Will you try once again? What to do? 89 years. 89 years, one of them is 89, another is 57. ଯାଇକି ଥରେ ପଚାରି ଦେଇ ପଳେଇଲେ ହବ ଥୋଡି police has to, you know. Although 31, although a report has been submitted by the
Similarly, my lord can
Bihar वाले Bihar हेले भी तो local police can contact Bihar local police station and contact the and get some information. Right.
similar two other items are there. My lord, Mr. Raj is there. Item number 39 and 40, 323 offense. It can be undergone or fine.
323 undergone period find out.
But
Just check it up and tell me.
My lord,
Or fine is there. Fine. Who will impose fine? By maintaining conviction. Undergone. That is undergone and this is or fine.
fine or PO,
Fine 5,000 rupees
or PO act parent.
or PO or something.
24 item lordship.
Note down and tell me so that I can finish. Note down and tell me. And let me finish 31 first.
24 you
1 minute, madam. 31 I'll get. Although a report dated 1/7/2025, 10/7/2025 by the IIC Sector 7 Police Station, Raurkela, has been placed on record stating that the whereabouts of the appellants are not. However, Mr. DP Naro Senior Counsel submits that one of the appellant is about 85 years old and the other one is nearing 60. He has tried to contact them through the briefing council, but there is no headway. Hence, he requests that a further report may be sought. Accordingly, the State Council is directed to obtain press report regarding the whereabouts and well-being of the appellant. Please on 11th. 11th.
I mean, pardon me, lord.
95 matters, why 4 weeks? See, if you want to do, you can do it within 2 days. If you can't do, you can't do it, even after 6 months. Only one phone call. Concerned police station, you just pick up the phone and call. Bihar also there is a phone. Try, why are you so apprehensive? It doesn't happen, then I'll give you one more date. But this will go on like that. Level. If it doesn't happen, then we'll see. Yes.
Item 19 meter, Madam Miller, order dated 14/10/99 of the special judge shows that they all are released on bail. 13 they are arrested. 13/10/99. You see order dated 14/10/99.
Item?
Item 19. Order dated
In
14/10.
that case where your lordship has held that he has undergone more than 10 months. But
he says something else. Let us see.
date ta कितने?
1 minute.
14/10/99. 14/10/99 of the special judge.
Order sheet मैंने
Sir, I put here say order.
order sheet मेरे first
Order sheet.
Order sheet.
order sheet first
Number?
order sheet ए last to the table contents तापर order sheet.
Table content, then order sheet.
No, order sheet, you tell me.
Order dated 14/10/99.
14/10.
Third order.
Third order. That's we got it.
14/10.
99.
Yes.
This order relates to the bail petition moved on behalf of accused persons Gulu alias Sasank Ratha.
No, 14/10 is something else.
14/10/99.
99.
99.
The order sheet starts with 2001.
14/10/99 order is not there. The order sheet starts from
2001.
2001. Where you got that?
Sir, कितने पेज रो अच्छा है?
First one, कितने पेज देख?
तो ऊपर देखो तो पेज दिखाई दे।
14 पेज इधर
There are 14,1099. So relates to bail petition of one.
14,1099, where is the order? Can you see that? Is there?
Yes. 14,1099. Which are relates to bail petition moved on behalf of accused
इधर
person.
415 होती थी।
Where was it? 415. Yes, 14,109. This order is related to the bail petition moved by the accused. So and so, so and so. Appearing for then bail is granted.
बोलू शशांक तर बरोबर गोकुळांत रावटला टिकेट फोटो चौदह 14 शशांक रहा गोकुळांत रहा शशांक गोकुळांत देन पुन्हा alias शशांक गोकुळांत नारायण शशांक गोकुळांत अच्छी गोपाळी अच्छी गोपाळी अच्छी these three appellate pillar Sasanka Ratha Gokulanda and Gopala.
Few of them are absconding, and on 29/11/99 they also surrendered.
Right.
And on the basis of the co-accused being
Yes, right.
granted bail,
That
they
right.
were also granted. So there is no undergone period.
Right.
No undergone at all. P only. No undergone.
And I had seen yesterday, that's why.
Only PO. No
item
question of
25.
undergone.
Item
PO
25.
कर दीजिए, दे दीजिए.
Okay.
Item 25. Item 25, small case, already harding part at length.
Small case.
25.
हाँ.
It is a 354 allegation, 3 SC active was there. In 354, only 3 SC act, 6 months conviction is there. And so far PW3 and PW7, son and daughter, the father and daughter, they have not supported the prosecution case.
Then it needs to be heard. After lunch I'll hear it.
Next.
Small matter, it will be disposed after lunch, we'll make a call.
After lunch, first case.
Okay, we'll see. We'll see.
After lunch.
Short methods. Which matter?
The citation.
Got the cited.
Item number 14 valid, the two NOCs which has been referred, I have brought it valid in the meantime. And another judgment also, where Honorable Justice B.K. Behera has defined what is grievous hurt.
Hmm.
In the case of 307, 326, as because the injured was not there in the hospital for 20 days as inpatient, as per the definition of grievous short in the illustration attached to it. Court has converted it to 324. That is Tunu Panda versus State. I just strike it up and I got it in the board itself. Well, that has been decided on Justice BK. It's a case of 307, 324, 320, 326 by 34. Judgment was delivered. Converted to 324 at period of Ramadan. Finally, judgment. Yes.
Which paragraph?
Justice BK Patra. Yes, judgment.
This is a case of dislocation.
My lord, here, my lord may see, judgment of Honorable Justice BK Vera is also there in my lord. It's Tutu versus State of Orissa, decided on 15th December 1986 by Honorable Justice Behera.
Where is that? This Behera one.
My lord, can you get?
X-ray is required. Yes. Yes. Grievous. Where is that grievous? Tell that in the absence of report and the evidence of the doctor who held the X-ray examination and prepared the report. Report below it. Here, in this case, the X-ray was done and it was not placed on record.
Here, my lord,
And in the other case, it is a case of dislocation.
my lord, here, my lord, in the judgment of the Honorable Justice BK Behera, it will be there, my associate got
Which
it
one?
from this.
Which one? 70?
That is my lord, criminal revision number 39 of 84, decided on 15 December 86, Tunu versus State of Orissa. No, my lord, here in this.
Then you tell your junior to give these three judgments. I'll keep it and.
My lord. And also, judgment of apex code is there, but
No, on all these cases where doctor says that it was referred to X-ray or X-ray was done, even X-ray was done, it was not placed. Then
to reach at a conclusion that injury is grievous or not, my lord, here the Honorable Court has been pleased to observe. The next question for consideration is as to what offence had been committed by the petitioners. It's a case of 307, 326. The Lord and Appellate Judge has held that the grievous hurt had been caused to PW4 13 as the latter had been unable to follow his ordinary pursuits during the space of 20 days. As would appear from his findings, no other clause of section 320 of the code defining grievous hurt could be made applicable to this case. Section 320 of the code provides that any hurt which endangers life or which causes the sufferer to be during the space of 20 days in severe bodily pain or unable to follow his ordinary pursuits would be constituted to be a grievous. The mere fact that a sufferer has been in the hospital for 20 days or more is not sufficient to attract this clause. It must be proved that during that period he was in severe bodily pain or was unable to follow his ordinary pursuits. A person with some injuries may be capable of following the ordinary pursuits long before 20 days are over, but may remain as convalescent in the hospital for the sake of permanent recovery or greater cause of recovery. In the instant case, there is no clear and acceptable evidence that PW14 was suffering from severe bodily pain for 20 days or more, and that he was unable to follow his ordinary pursuits for such a period. For these reasons, the learned counsels for both the sides are agreed that offence should be one of causing hot punishable under section 324 of the Indian Penal Code. I would accept the contention raised on behalf of petitioner's concession and accordingly is pleaded on.
Now, even if by maintaining your entire endeavor is to convert it to 323,
My lord.
let it be 326. How does it make a difference to you?
Nothing. If you not.
I'll give PO, either I will convert it to 323 or 324 and give PO. Otherwise, also I'll give PO. Why are we unnecessary? I'll give PO and finish it up. PO. Because he was 41 in 1999, I have seen it. Now he must be about 70, 71, like that. So why to send him to jail? PO. And you said two matters, short matters you said, 39 and 40, let us see. Short matters. So we'll finish it up. 39 में क्या है? What happened in 39?
39 में 323 थी ना, 6 months थी ना, same day surrender, same day bail. तेरा PO
34.
323, 39.
No, he was 34 at the time of incident.
Huh?
Getting charged for
34.
acquittal.
75 years old.
34.
PO कर दो
Aye.
PO कर दो
Aye.
PO कर देंगे. Then another one is
40 ଟା sir arrest ଥିଲା 31/8/94 ଆଉ bail ପାଇଥିଲା 22nd 9/94 23 days period.
custody.
CB 323.
323 140.
Arrest
of 31st August 1994
31st 8/94
ଆଉ bail ହେଲା 22/9/94 9/94
94 कितने दिन वाले
23 days हो
23 days
323 by 140.
323 10 sentence कितने देगी
6 months
already undergone कर देंगे
Aye. Aye.
because see the age must be you were 32 in 1998 another
32 1996
65 years.
65 years what will you do undergo na
Aye.
No, under the still it in the review the PO would undergo all the 3 matters. I don't know. Yes. Any matter? Yes, madam. 24.
Yes, my lord,
24.
13 appellants are there. Lord, out of them, 4 are dead now.
Only 5 members.
5 persons are alive and the rest 4 persons probably instruction is not there. It is a case, my lord, they have been sentenced to pay a fine of 600 rupees each. Yeah, under 506 only. Though they have faced trial under various sections 147, 427, 506, 294.
They were acquitted in all the charges except
Face trial under this section, they have been acquitted of these charges, and only 506 remains, and they have been sentenced to pay a fine of 600 rupees each. That is the judgment under challenge now. Here, my lord.
you are ready to pay or you are not ready to pay?
My lord, though it's a very small pity amount, but still a conviction, still a stigma to the person.
They are government employee what?
They're aging persons, when they're more than 70. So I was just asking.
All of them are 70.
Almost.
The youngest amongst them was 43
in the year 2003.
33, Your Lordship. 12.
33, yes, 33.
33. Yes, Your Lordship.
That is Kalia Meher.
Yes, in
And
2007.
rest of them are in their late 70s. Didn't it?
Yes, Your Lordship. 60, 50, 46.
What was the initial charges? 147,
Initial balance 147, 427, 506, 294.
506 bonla kemti.
No, there is a threat. The allegation.
Along with the SCST, all have been acquitted except the 506.
Except 506 only. PW1 is the informant, Your Lordship. And 457 are said to be the eyewitness.
4?
457.
7 has become hostile. So
Yes.
4, 5.
4,
And-
5 remains on. 7 has not supported the prosecution case.
So 23 na? 24 na, yes. Show me the evidence. Relevant evidence.
Yes, sir.
4, huh? PW 4.
4.
Let's start with the PW1. He's the informant.
One is the informant, my lord, who was not present at the spot when the alleged occurrence took place. He was
No,
not at the
no,
spot.
The court
Kindly
didn't
please
believe.
PW1.
Court didn't believe all these witnesses.
Yes, Your Lordship.
Why court has believed insofar as 506 is concerned?
Yes, sir. Let me place, I'll place the evidence of PW1, 4 and 5.
Yes. Where is it?
So, PW1, Your Lordship.
Yes.
I am the informant. I belong to the scheduled caste. I know the accused person. They belong to general caste. On 5/6/2001, at about 10 a.m., the accused person didn't allow me to stay in the house by stating that ଗଣ୍ଡ ମାନଙ୍କୁ ଆମ ଗାଁରେ ରଖିବାକୁ
ठीक है, that HCST.
the villages and the accused person hold a meeting to demolish my house, to drive me out from the village. When I heard about the meeting, I went to the police station to give information. While I was in the PS, I heard from my son who came to the PS that the accused person forcibly drove my son and my wife and others from the house and demolished the house. So there are 2 occasions they have threatened the informant. Yes.
Very threatening.
They also removed the utensils, wearing apparels, the door frame, and so on, so Your Lordship. There are PW4.
No, where are the threatening?
Your Lordship,
They have done it, done the job. No threatening.
Your Lordship, there are 2 occasions. From the first occasion,
From the PW1 evidence,
from the PW1.
there is no threatening element.
Yes, Your Lord,
Where is that?
statement.
Where is that?
In the first place, the accused person did not allow me to stay in the house by stating that Gondamanuk Amagari Rokhe Duguni. The villagers and the accused person hold a meeting to demolish my house and to drive me out from the village. Then I heard about the meeting to enter while he was in PS, another round of litigation happened, Your Lordship. There are 2 rounds of litigation.
You can't imply
No, Your Lordship, I'm
unless
implying.
specific things are there.
Your Lordship, while PW1 was present in the village, he was charged by the accused person that they won't allow him to stay in the village, first of all. And secondly, they said that we will hold a meeting and to do the conformity. Then he went to the PS where at the same time the accused persons assaulted his wife and son. Then I will place PW4 for a minute, Your Lordship.
4.
Yes. So, PW2 is the son and the 3 is the wife who are the victim of the circumstances. PW1 is my father. I belong to the scheduled caste. I know the accused persons, they belong to the general caste. One either of the month of May or June 2001 at about 10 a.m. The villagers hold a meeting to demolish our house. So my father went to the police station to lodge a FIR. Myself and my mother were inside the house. Then the accused person came, being armed with lathi, crowbar, kodi. When I came out of the house and protested, the accused person abused us in filthy language, saying so and so. Then the accused person drove my mother, my sister, myself, and my elder brother of my father from the house. They demolished the house. They removed the door frame, so on, so Your Lordship. So 506 is there, Your Lordship.
Implied.
Implied. Not implied, Your Lordship. They say, myself, my mother were
Very
inside.
direct
Then
threat.
the
They have acted upon.
They
They have not threatened. They have acted upon.
have acted upon it. Your
Acted upon.
Yes, Your Lordship.
And the trial court doesn't believe the acting part. So therefore acquitted.
Yes.
Where is the threatening then?
I'll
I will kill you. If he says I'll kill you.
Yes, Your Lordship.
This is one offense. 506. And he is already killed.
They
If
drove the
302
persons out here. Yes, Your Lordship.
And if
Exactly.
302 you are there acquitted,
Yes, Your Lordship.
can you say that
307 would
Right out.
be. I consider that.
Then for the act they were acquitted.
Acquitted. Yes.
Where is the threatening part?
That has been believed. Your Lordship, there are consistent. So
Then
there
because
are
of-
statements on record. There are
Want to
other.
convict, then you can convict. You just see
May I place PW3?
PW3.
3.
Okay.
PW3 is the wife of the informant.
Hmm.
Sadilka sir, about 3 years back, I was in my house with my daughter and son. The villagers came with lathi, spade, crowbar, and demanded document in connection with the house in which we were staying. The brother of my husband protested. Then the accused person abused us in the obscene language. Then the accused person drove us from our house and demolished the entire house and so on. So
They have done it.
they done it. They threatened and they
Where is threatening
intimidated.
you? So show me.
The language is there, Your Lordship.
Where is it? You can't.
Then
You can't
accused person
impliedly get something. Where is the threatening? The element of threatening.
I'll just replace the statement. The villagers came with lathi, spade, crowbar, and demanded document in connection with the house in which we were staying.
Yes.
The brother of my husband
This is the
protested.
overtake. This is the overtake.
This is the overtake.
And the overtake is done.
Your Lordship,
No
this,
threaten.
Your Lordship, this overtake in conformity with the 506 ingredients, Your Lordship. I'll just place.
Then every act, along with every act, then you will bring 50.
I'll just place 506 for a minute.
Oh. Because 506 itself is an offense.
Lordship, may I place it? For 506, 503 is the which holds the ingredient criminal intimidation. Whosoever threatens another with an injury to his person, reputation, or property, or to the person,
Read it slowly. Read it. Whoever threatens
whoever threatens another with an
an
injury to his person,
his person. Where is
reputation,
that?
the injury. Lordship,
I
the
will
moment
kill you. Threaten.
they're wearing the armed weapons.
They
Lordship.
have, see, they have not threatened, they have done it.
They have drove them out of the house.
See, there are two elements.
Yes, Lordship.
Threatening and doing it.
Yes, Lordship.
If they have done it, there is no question of
Lordship,
506.
I'll go to the second bit. I'll go to it. To his person, reputation or property, or to the person, reputation of anyone in whom the person is interested, comma. This part is
With an intent.
with an intent to cause alarm to that person.
Hmm.
Your Lordship, I'll be stressing out on this part only. With an intent to cause alarm to that person or to cause that person.
Why don't you understand? Intent is something different and done is something different.
Yeah.
He had no intention, he has done it.
Sir, they have drove them out of the house.
To do something with an intention you are threatening is
Yes,
one
sir.
thing,
Yes, sir.
and doing the act itself is one thing.
My submission, they wanted to alarm the
With an intention.
victim.
With an
With
intention.
an intention to make them.
Suppose somebody comes with arms and ammunition
Yes, Lordship.
and come to your house and shout and say that yes, I will kill you and all.
Yes, Lordship.
They came and this is a criminal intimidation because they haven't done.
Yes, Lordship.
They intend to do it.
Yes,
They have not committed the crime.
yes, Lordship.
Once they do it and that is not believed by the court, they get inside the house and they attack.
Lordship, there are two parts.
Then there is no intention. They have done it.
Lordship, there are two parts. PW1, PW2 and 3, they say, the villager, the accused person, they said that we won't allow you to stay in the village. And the second part is that to that act, they drove them out of the house. There are two parts, Your Lordship. Your Lordship, may I reread?
Yeah,
to one?
you see, evidences are not to be interpreted. Evidences are to be read.
Yeah, consider, Your Lordship.
It's
Well-
not the statute book that we read the provision and start interpreting.
Lordship,
You don't interpret evidence. Evidence show me where the element of threatening.
Your Lordship, I'm just rereading the PW.
Any evidence.
Yes, Your Lordship.
Your interpretation may be correct.
Yes.
But my interpretation is also may be correct, or her interpretation may be correct.
I'll
Interpretation is a
place
subjective
only
thing.
that particular thing that with intent to cause alarm to that person or any person who is interested in it. That person. PW1 says the accused person did not allow him to stay in the house by stating that Gondamanaku amagare rokhei debuni. So that is the act to be done. And the threatening is that, Your Lordship, the accused person did not allow him to say, so that for which he went to the police station. Thereafter, PW2 and PW3 were the victims. PW2 states the accused persons came being armed with lathi, crowbar, kodi. When I came out of the house, protested, the accused person abused us in filthy language, saying.
Forget it. Now, let us come to the reasoning of the trial court.
Yes.
Why 506?
Before that, can I place PW4 and 5 who are the eyewitnesses but not the family members? Can I place?
5, okay.
Yes. PW4, paragraph 1, Your Lordship. Third line from the top. The accused, at about 3 years back at Tuesday, at about 10 a.m., the accused persons came with spade and crowbar to the house of Kalyanag and demolished his house by removing the family member of Kalyanag. They also taken.
PW4, there is one sentence is there. They also threatened.
Yes, Lordship. They also threatened those Gonda people who would protest, they would be assaulted.
This is 3.
This is 506.
This is direct 5.
This is 506. Yes, sir.
Why are you bringing so many things? Read.
So the eyewitness, the victim of the.
And let us see the cross examination, how it is demolished or
yes,
sustains.
He has stated it is not affected. Only suggestions are there. His version in the chief is intact. He says, I am not the son-in-law of Sonsa, I am married to Sonsa. I purchased the land in the village.
And let us see 5.
PW5.
5.
PW5, Your Lordship. I know the
PW5 is not said threatening part. Only PW4 is there.
PW10 evidence, Lord, may I place Lordship of the IO.
PW5 will not help. PW4 only help.
5 only say that they drove them out from the house.
That's the act. That's the overtake, which has not been believed by the court. Overtake is not believed. Next. Any other evidence? Only PW4 is the isolated.
1, 2, 3 also in terms state that they have been abused, they have been threatened to.
And they have not said that.
That particular word may not be used. They say that they are armed with deadly weapon.
All of them are saying they came and did this job.
Yes, sir.
And that the job which they have done,
yes,
that is not
have been acquitted. That have been yes.
Only the 4, yes, 4 has very categorically said
threatened. Yes. He has
that evidence.
That very word.
Let us see now what trial court says.
Yes.
One thing, my lord, the IO's evidence needs to be gone through, Your Lordship. But 1 or 2 paragraph may I place. The PW10 IO.
Come to page 15, para
13.1. 13.1.
Yes.
I'll start with the 13 year
13 only. 13. The evidence of PW3.
The evidence of PW3 shows the group of villagers variously armed with emerged and insisted for documentary evidence in support of their claim. The participating role of the accused person in that mob, not whispered by PW3. The fact remains that they insisted PW2 and 3 not lay and claim over the site, asked them to leave the village unless they drop their claim. This being the essence of the evidence, which remain intact on close scrutiny, the remaining evidence being chaff and not gain. I now divert the other aspect to ascertain whether the evidence is sufficient to attract the mischief of Section 506. Section 506 IPC deals with the punishment of criminal intimidation. Section 503 defines the said offense. A simple glance at the 503 IPC shows that the gist of the offense is that effect which threat is intended to have upon the mind of those persons threatened. Intention must be cause alarm, and whether he is alarmed or not is the really of no consequences. But material has to be brought on record to show that the intention was to cause alarm to that person. The anxiety and the mental anguish caused by an injury threatened may often be as and even greater than the usual injury. The intention is a mental condition which has to be gathered from the circumstances of the case. The threat must be intended to cause alarm, for which it must follow that ordinarily it would be sufficient for that purpose. Degree of such alarm may vary in different cases, but in the essential matter is that it is of the nature and extent to the unsettle the mind of the person on whom it operates and takes away from the acts that element of free voluntary action which alone constitute consent. For all that has to be proved is that threat was given and the alarm was due to such threat. Threat referred to this section must be a threat communicated and uttered with an intention of being communicated to the person threatened for the purpose of influencing his mind. As held in the case of Amulya Kumar Behera versus Nabagana Behera, it is held that the question whether the threat amounts to criminal intimidation or not does not depend on the norms of an individual threatened. If it is such a threat as may overcome ordinarily free will of a man of common firmness. Threat is the declaration of an intention to inflict punishment, loss, or pain on the another. Injury is defined under Section 444 of the IPC. It involves doing of any illegal act. If it is made with an intention mentioned in this section, it is an offense. Whether the threat was given with an intention to cause alarm to the person threatened has to be established by evidence to be brought on record.
Is it the intention to cause injury?
Intention to cause alarm to the person is allowed. The paragraph 14, he analyzes the evidence. May I place it? Evidence of PW 1 to 5, when pitted against the existing settled principle of law, referred to. I am convinced that the words uttered and the physical gesture exhibited in the course of that incident where demand was made to produce evidence in support of the claim, and else to drop the demand was such a nature and extent that
it says that that gesture itself is
yes,
the
yes,
threat.
yes, sir.
Yes, well reasoned. Yes, madam, what do you say?
Milord,
Well reasoned.
yeah, my.
See, two things.
Yes.
4 says direct, there is a threat. And other witnesses say that you came, demanded the document, and you said that we will not allow you to stay. The court says that the section 44, taking aid of section 44, which describes what is injury, it says that the mere fact, the words uttered and the gesture, if there is an element of threat
in the mind of the
then
person,
mind of the person who is doing it, that itself is
506.
satisfied 506.
Yeah.
And reasoning is absolutely correct.
Yes.
My humble submission would be, Lord, the threatening, the part of threatening, Lord, as your Lordship has very correctly pointed out, in the evidence of PW 1, 2, and 3, there is nothing regarding the threat.
The gesture would be there.
Causing alarm, no, what the definition says. Lord. Only in the evidence of PW 4, he says, they also threatened those Gonda people who would protest, they would be assaulted. Blood, from this sentence, also, blood, it cannot be said. He came and he says Gonda people, he threatened the Gonda people. And these are the.
Yeah, what is in
that is
their
not
mind,
specific.
accused mind while saying so? Saying so, we will not allow you. That itself is a threatening. That's what the analysis is.
But it cannot be said that this sentence, this threatening was from this evidence. It cannot be said that it is a specific threatening to these informant and his wife.
It is his family only.
It
is the family, exact family.
Gonda people means all Gonda people.
Again, see, Yanko is threatening the
See, therefore, 503 says that if it creates a alarm for the person and persons,
Well, there is no evidence that this threatening was given to this informant group or informant or his wife, my lord. And moreover, PW4 statement, my lord, it is also very contradicting in the evidence of the IO. Before the IO, he has stated something else, your lordship.
Who?
Before the IO, PW10, your lordship.
PW10 IO. Yes, it will be. Yes.
PW10, your lordship would find at page 9 with regard to PW4 evidences. It reads like this, my lord.
Which para?
Paragraph 9.
9.
PW10, paragraph 9.
Yes, madam.
I have examined
Kulamani.
the PW4. It is a fact that he has not stated before me that the accused person removed the household article, but he has stated before me that the accused person had not taken away any household article. He has also not stated before me that accused person stated that they would assault Gonda people if they would protest. It is a very contradicting statement he has given before the IU. The
161 statement.
The only prosecution witness, my lord, and only one sentence. First, my lord, that threatening part is not specific to this informant or his wife or his son. Se kale threaten e Gonda lokongo rakhe devoni. Which Gonda people the threatening was for, it is not clear.
Generally.
In general, say what a group se Gonda people rakhe devoni. It cannot be construed as threatening to this informant party. My submission is that, my lord. And moreover, that only prosecution witness, PW4, he has stated something else before the IU. Pura contrary,
161 statement
contradicting sentence they have.
Now let us see what you are saying.
Yes.
That it is a general statement made.
Yes, Lord.
No specific threatening to the informant.
PW1.
Let us see PW1 again. Informant. Informant is PW1.
PW1 is
Let us
informant.
Accused
And
person did not allow him.
It's not present at this point. He heard this occurrence.
No, there are two parts of the occurrence. One part, the accused person threatened PW1 for which he went to the PS. While he was in PS, this person assaulted his family members. And PW2, 3, 4, and 5, there are the
Has been threatened.
Villagers and accused persons. Holding a meeting to demolish the house and to drive.
PW1 may I place, your lordship. I am the informant. I belong to scheduled caste. I know the accused person, they belong to general caste. On so and so date, the accused person did not allow me to stay in my
allow
house.
me to stay in the house.
By
So me as in him only.
the villagers and the accused person hold a meeting to demolish the
My house.
So,
And drive me out from the village.
when I heard about the meeting, I went to PS to give information. While I was in PS, I heard from my son. They called police station. Then he heard from the son, who came to the PS, that the accused person forcibly drove my son.
Not only threat to the community, it threat to him also.
Yeah. See, in general, say कहले हमें रखे दबोनी गोंडा वालों.
But he being a Gonda, he got threatened.
Not a specific threatening to the informant party. That is my submission.
There is two way of doing it.
Omnibussly say
Move out there, same as allow me to stay in the village and drive me out of my house. That goes to show that this specific overtact
And the other PW 2 says that when the accused person drove my mother, my sister, myself, and the elder brother,
Yes.
my father, from the house.
From the house.
They demolished the house.
Yeah.
They removed the door and door frame, utensils, so and so, so and so.
That part
That-
is not. That part is not believed by the.
That part is
court.
not believed that.
Yeah,
You're
that
right.
part is not believed by the court.
The
And
only thing,
the
only thing
The only thing what I am still not convinced is the act is not believed.
Yeah.
And the threatening, the act goes,
part
and the
is-
threatening part, how will you believe?
How can it be said
another
that
thing it is
intention
their
is-
favor of the accused. 313 statement रे किछ particulars देना
किसी भी ना-
खाली 3-4
Threatening वाला
question
506
किसी नहीं
I
that should have been
I
very
saw
particular.
I saw that. I saw that.
ତ ଫାଇନ୍ ଅଛି ଦେଇ ଦିଅନ୍ତୁ ଆଉ କ'ଣ ଆଉ ଏତେ ଦିନ ହେଲାଣି।
No, no. She is saying that it's a case of equitable. Many people are there who we don't know whether anybody is working, anybody is politician contesting. We don't know. It will hurt them.
Still, it's a conviction, my lord.
ମୋର ଖାଲି ସବମିଶନ ସେ 506 ର ଇନଗ୍ରେଡିଏଣ୍ଟ ମେଡ୍ ଆଉଟ୍ ହଉଛି and specifically
Made out of whatever you are saying is correct and the analogy is correct.
yes,
But the fact that the same witnesses are not believed, qua the act,
no, qua the act maybe the threatening part and the gesture of the accused has been believed. That gesture has been.
the act is not believed. How the other part is believed?
Your Lordship, may kindly see the.
Either you believe the witness fully or you don't believe.
Your Lordship, may kindly see the initial sections under which they have been charged. You kindly see the.
If you want to justify a conviction in good English, you can write anything.
No, no,
Equitable also can be written in the similar way.
no, I mean, I don't.
But you see, the fact that the other offences, they were tried for not only one offence, they were tried for many offences. Initially, they were charged for 147, 427, 506, 294, 149, scheduled cast, scheduled tribe, everything.
Yes.
And the witnesses were not believed for all the offences.
Yes.
3 SC.
And you leave everything, get the extract from there. Everything is not believable, but the threatening part is believable.
Threatening part.
How can it that? Okay, good. Take madam's name and phone number also. So make it straight. Yeah, talking with all that. Next time you could ले दो. कितना लगा उसको? I think we'll stop today. 7 judgments reserved. I'll have to. Oh, I think.
25ଟା ଛୋଟ ମାଟରଟା ପାଠାଡ଼ ମାଟରଟା
25. I didn't want to reserve many judgments, but 7 judgment means, writing is matter is small for you. Anyway, let us see. 5, yes. Yes. Oh, what is the offense?
Offense well, initially charges were submitted 341, 824, and 354 and 360. In the trial stage, compromise petition was filed on section 320.
320.
And compromise was also held under section 341 and 324.
Yes.
And so far 354 and 360 is concerned, the Learned Court has held 354 acquitted. And so far 360 is concerned, he has been convicted on for period of rigorous imprisonment for 6 months. And in this case,
what happened to the settlement? What happened to the settlement?
Settlement, both parties filed the application under section 320 before the trial court. And trial court rejected that application.
It is not compoundable.
Allowed the so far 341, 324, but rejected 354 and there is
It is not compoundable, that's what.
360.
Do you have any judgment where the party settled, then even SC/ST can be? No, it can't be. That's what I'm asking. Do you have any High Court judgment or anything? In a particular facts? See, these are the matters.
That also, this honorable court by the Honorable Justice L. Mahapatra has passed one judgment. 2004-27 OCR, page 127. In that case, 3 Act is also there. In that case, the Honorable High Court has held that if the party are agreed for compromise, there is no necessity for prolonging the litigation. Hence, directed for compromise.
482.
482.
482 is a different.
482 question of the
Convicted. See, already you are convicted.
Right. 482
482 is a different
at the
jurisdiction.
stage of trial, Your Lordship may kindly have a glance at the statement of PW7. Who is
PW7,
the
victim.
Who is the victim?
Yes.
Page 66.
The certificate is placed on record.
Yes, ma'am. That has been proved by the Tahsildar, that civil custody training.
Okay.
Cross-examination part I am just reading. Myself accused have not compromised.
Where are you reading?
Huh?
Where
Page 67 yours. Cross examination starting. Para six.
Cross-examination.
Cross-examination.
Yes, sir.
Para 6.
Myself and the accused have not.
Hon'Ble has not pulled me with any validation. He is a resident of my father. My family used to wash their clothing also. I had no illicit relationship with the accused. That is the and so far 3 SCST Act and so far overt act is concerned, his father has examined as a PW3. What he has stated.
What the victim has stated, let us see.
Yeah, PW7.
Come to para 4.
Para 7.
Yeah, those
Come to para 4 first. About 3 years back on the date of 10 so and so, I had been washing cloth and at that time I broke the branch of the mango tree from mango grove, and at that time the accused came and pulled my blouse and the regent of police.
Nobody has corroborated the
and raised the cry, and hearing my cry, city and other only used to sustain the injury.
When the accused ran away from the spot, he left the napkin behind. That was also seized.
That has not been proved.
How do you say it is a small matter?
Like,
It
small
needs
matter,
to be
but
appreciated.
it has been already compromised between the parties.
Compromise, you show me some judgment where after conviction also.
Like before conviction, compromise was there.
But you should have filed for 482. You didn't allow it to happen. Invited conviction.
For it to file college, trial court to he has to consider filed 482.
Find out some judgment would be there from some high court.
And so far, other aspect is gone. PW3, which is the father of the.
But then appreciation of evidence is different issue altogether. Then on
Nobody has.
it needs to be heard at length.
And nobody has corroborated the evidence of the.
That we'll appreciate that. You should get some judgment. If you say that in SC/ST Act also, if the parties have settled, particularly if the other offences are there, and partly the trial court allows and partly refuses to allow. What do you
complaint case filed by the opposite party against the petitioner, the cognizance of offence under 341, 323, 294, 506, 34, and 3 SCST Acts have been taken. Matter amicably settled between the parties. Opposite party filed a petition under section 257 CRPC before the magistrate for withdrawal of complaint. Magistrate rejected the.
When that in your case, when the compromise happened before the evidence,
trial court.
before the evidence was recorded.
No. Huh? During evidence, that judgment also reflected.
No. You tell me the date when the witness PW7 evidence was recorded on
24
January 2005.
2005.
Okay. When the compromise?
2006.
2006. Maybe 2006.
5.
When the compromise? Let us see. 2005. Signature is there. When the compromise?
Compromise judgment.
Dated.
Judgment it has been reflected. Page.
When the
Page 2 of the judgment.
yes.
The learned SDGM having taken cognizance of offence 341, 354, 323 IPC and 3 SCST Act, committed the case of the Court of Sessions for trial. On 7/1/2004, charges were framed and the trial commenced on 24/1/2005. When the complaint was examined as PW7, an application under section 320 was filed for compounding the offences with necessary petition to accord permission for the same. During evidence also, she has filed.
No, but in the cross examination, he says that I have not compromised. What to do?
ମୁଁ ସେଟା ସାରା କହିପାରିବିନି ମୁଁ ନିଜେ ଟ୍ରାଏଲ କୋର୍ଟରେ ମୁଁ ନିଜେ କରୁଥିଲି
I'm just
already matter has
just
been
see
settled.
para 6 of the cross examination. He says that
Sir,
myself
no,
and
no,
take you
no,
have not compromised.
କାରଣ ହାତରେ ଲେଖା ହେଇଛି ସେଟା
Seven ବି ତା ପରଟା
then type ହେଲା ସବୁ ସେଟା ହାତରେ ଲେଖା
Then
ହେଇଛି
show me the compromise application if you have.
compromise application is there.
Where is that?
That is during evidence. It has been clearly reflected
Give
in
the
judgment.
show me the date.
Uh,
Where is the compromise application?
sir, compromise petition ଟା compromise petition ଟା ହେଲା sir 24/1/2005. Both parties filed compromise along with
24?
24/1/2005.
On the same day the evidence was recorded. And he says that no compromise.
ସେଇଥିରେ ପୁଣି allow କଲେ
Which is to be believed. The evidence has to be believed.
ସେଇଥିରେ ସାର୍ ପୁଣି allow କଲେ 341 and
That's the problem. On the same day, that is 24th January 2005, his evidence was recorded. And he says that I have not compromised.
ବାପା ବି ଷ୍ଟେଟମେଣ୍ଟରେ ସେୟା କହିଛି ଆମ ଭିତରେ କମ୍ପ୍ରମାଇଜ ହେଇଯାଇଛି
That's the problem.
as my daughter's marriage is heading I don't want to proceed in this case we have already
You get some judgment if you can.
ନାଇଁ ପିଡବ୍ଲ୍ୟୁ ଥ୍ରୀ ଯୋଉ ଫାଦର ସିଏ ତାଙ୍କର ଇଏ ହେଲା 16 ମାର୍ଚ୍ଚ 2004 ସିଏ କହୁଛି ଟାଇମରେ ହେଇଛି କିନ୍ତୁ ଇଏ 24/1/2005 ରେ କହୁଛି ହେଇନି
ହେଇନି ସେଇ କଥା ନା
ଏଇଟା ସାର୍ ଦେଖୁନ
Whether
ଥ୍ରୀ ଟା
I saw that. Therefore, I'm asking.
ସେଠାରେ ସାର୍ ଟାଇପ ହେଲା ସବୁ ହାତରେ ଲେଖା ହେଇଛି ନଟ୍
How do I know? The record says something.
ସେଟାକୁ ତ କହିପାରିବି ଇଏ କରିବିନି କିନ୍ତୁ ମୁଁ ନିଜେ କ୍ରସ୍ କରିଛି ନିଜେ ଟ୍ରାଏ କରୁଥିଲି ସେ କହିଲା ଯେ ଅଲରେଡି
ଦେଖନ୍ତୁ ଯଦି ହେଇପାରିବ try. Okay. Anything else and
I will be pardoned to mention, Your Lordship, there is a old matter, 1997 matter, Your Lordship. I have been appointed as an amicus curiae. Somehow this matter is not getting listed. Last occasion also, I have mentioned specifically for this matter. Your
Which
Lordship.
item? Sorry.
Case number
is it?
similarly 268.
ନାଇଁ ସେଟା କେତେ ଦିନ ମିଳିଛି କନଭିକ୍ସନ
Conviction 2 years.
2 years ରହିଲା
2 years. Offense?
Offense section 324 of IPC.
324. Please it by your short matter.
Yes.
When do you want to just have you prepared any note?
I'm ready with the argument, Your Lordship, and I'm prepared. This matter was supposed to get listed today itself, but somehow it did not get.
Put it on 11.
Let it come on 6th, Your Lordship.
6th, I don't know 6th.
6th is Thursday, Your Lordship.
Okay, 6th, you give it 6th. Let us see if I'm there. It will do it. 6th. Let it be on 6th. Huh?
Any next date, Your Lordship.
6th रखो देखते नहीं होगा तो फिर on 11th. ठीक है? Okay. Give the number and prepare a short note. Okay, thank you.
Thanks.
What I knew that.